Justices of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons having business to do before this court shall draw near, give their attendance, and they shall be heard.
Good morning. Please be seated. The first case for argument this morning is number 448, People versus Calera. The presiding justice is recused on this case. Counselor, good morning.
Good morning, Your Honors. May it please the Court, Carrie Connor on behalf of the appellant Dino Calera. Today I'll be focusing on points 2, 4, 5, and 6 of my brief. First, I would like to discuss the deprivation of Mr. Calera's right to counsel. A court violates the right to counsel when it only considers the accused's opinion on lesser included offenses. And in this case, defense counsel made multiple unequivocal statements that they were not requesting lesser included offenses. And regardless, the court continued to follow up directly with Mr. Calera to ascertain his opinion. This is very similar to Colville and Minkler because defense counsel clearly advised on the record that he was not requesting lesser included offenses multiple times. I would also like to discuss the lack of a mistrial despite unqualified jurors. A juror who has not heard all of the evidence is grossly unqualified to render a verdict. In this case, multiple jurors did not hear the court's preliminary instruction or the direct of the people's first witness. Upon learning about this, the court stated that they did not see how they could get around a mistrial. In the end, the court decided to do readbacks of the preliminary instruction and the direct of the people's witness, and this was not sufficient. The jury was unable to see the witness during their testimony and analyze the witness's credibility, and they were not able to have the benefit of the preliminary instruction when they were viewing the complainant's testimony.
Counsel, could we direct you to your first contention, which is whether the special district attorney had jurisdiction?
Yes. So the jurisdiction to prosecute lies directly or solely with the county's district attorney. There are limited exceptions, such as under county law, section 701, for a special prosecutor, and there's a very specific procedure that is meant to be followed.
Right. We all understand that, and I think there's no dispute that the special district attorney here was not qualified. The question is whether it's a jurisdictional defect or not.
Right.
You want to address that? There's some cases that they've cited that says that the residency requirement doesn't render void the indictment and all the prosecution.
Right. I think working family parties is one of the cited cases. And this case is different from that, as in working families, they merely failed to document the procedure of electing the special prosecutor, but the correct procedure was followed. In this case, like DeFalco, the prosecutor was unauthorized, and the correct resolution would be the dismissal of the indictment.
Anything further?
Just briefly, on point 5, the definition of motor vehicle and temporary inoperability was not properly clarified. Respondent suggests that whether a vehicle could be repaired is what the temporary inoperability turns upon. Under that logic, any vehicle could become operable with enough repairs and money. Dupra specified that the inoperability be temporary, and Hull versus Royal drew the line at whether the car could start. Carey found that a vehicle with an inoperable battery was not a motor vehicle within the definition of vehicle in traffic law because it was incapable of independent movement and lacked the immediate ability to become operable. And as just discussed, there is evidence presented that the vehicle was not a motor vehicle within the definition of a vehicle in traffic law. And the prosecution never proved this beyond a reasonable doubt.
Counsel, doesn't People v. Dunbar control when we're talking about the appointment of a special counsel?
Yes, Your Honor.
Okay.
Well,
Sorry, I'm not sure I understood.
In People v. Dunbar, it says that despite the resident requirement, as long as the chief administrative judge has the authority, the special counsel will be valid, correct?
That's correct. In this case, it was merely that the correct procedure was not followed, and since the jurisdiction to prosecute lies solely in the district attorney's office, with the exception for specific appointments and
But in
specific
People v.
procedures.
Dunbar, it says that that's not a jurisdictional defect.
Right.
So you agree that Dunbar applies here?
No, sorry.
Yeah, Dunbar was not a county law case,
Yes,
not a
yeah,
county
it
law
was a public
701
officer
case.
law,
It was a local residency issue
correct, yes,
under a different statute.
right, so that's a public officer law issue rather than a county law under 701,
All right, anything further?
nothing further.
Good morning, Anthony Bruce for the respondent, and I suppose I'm the one with the target on my back here anyway, so. This is an appeal by a 4-time convicted felon who committed the larcenies he's charged with while he was finishing out a term of parole on a prior conviction. The proof of his guilt was simply overwhelming, and he's asking this court to order his conviction vacated and the indictment dismissed on the thinnest of reeds. This court should reject that invitation, and I'll get to my reasons in a moment. But any other decision would lead to a total waste of police, judicial, and prosecutorial resources.
We're talking about a 2003 Toyota Highlander here, all right?
We are.
Right. Let's go to that jurisdictional issue if we could.
Sure,
Would you agree with me that the district attorney is a constitutional officer?
I would.
Right. Would you agree with me that that constitutional officer is chosen by the people of the county?
Agreed again.
Right. And there's very limited circumstances in which that district attorney can be superseded by someone else like yourself.
Agreed again.
And County Law 701 controls those circumstances, correct?
Yes.
And it says to the appointing judge, you've got to appoint someone from the county in which the district attorney was elected or an adjoining county. Do you agree?
I agree.
All right. And so, don't we have here then a situation where the judge is now superseding the voice of the voters in that county?
I don't know that I've ever considered it that way, Judge.
So the judge here is acting like an elector, and the judge's discretion is limited to those people who live in the county or an adjoining county, correct?
Well, I think, Judge, you're going a little, there was a mistake made here. I don't think this is any sort of extrajudicial act by Judge Church. I think a mistake was made. So I don't know that.
What's the mistake?
That I was at the time not qualified under 701.
Well, that's exactly what the issue here is.
Right.
And does that mistake then render you, in your actions, non-jurisdictional? You admit there was a mistake.
I do.
Right.
But it doesn't render it non-jurisdictional. If you read the various cases we've supplied to the court, Dunbar being one of them.
Well, let's stick with Dunbar then. Dunbar was not the appointment of a special district attorney. That was an assistant district attorney in Nassau County.
Well, there are no cases that we can find that deal directly with 701. I'll be quite frank on that point. All the cases that we found and cited to the court deal with the issue of residency, which I think is the issue here. And all of those cases, except for the cases that deal with where a prosecutor lacked subject matter jurisdiction or exceeded his subject matter jurisdiction, all of those cases, albeit decided under other statutes, say that where the residency is not jurisdictional. And that's our position here.
So you would acknowledge, I think you have, that you were ineligible to be appointed under 701.
I would.
You were, and yet the appointment was made. The question is, what now? If we say this is not a jurisdictional defect, and that despite the fact you shouldn't have been appointed, that we allow the indictment to stand and the conviction to stand, there would be no meaning to the statute. Would there, in other words, a court could appoint under 701, an attorney from anywhere in the state, or even another state for that matter, just appoint anyone they want, ineligible to prosecute, and if there's a conviction, say, well, the residency requirement, it's not jurisdictional, so the conviction stands. Wouldn't that be the meaning of what you're asking us to hold? In other words, there'd be no meaning to the statute.
Well, I think the meaning of the statute is that in the future, everybody who deals with the statute has to be more careful. I disagree with you with respect to the meaning of the statute. I think what the court has to do is look at it in the confines within the four walls of this case and go no further.
So for the next case, we might enforce it, but this one, we wouldn't.
I think it's fact-specific, Judge. I don't agree with you, I don't disagree with you.
How do you know it was a mistake by the judge? I guess that, I mean, did you have office at some point in did you have an office or live in the county at some point?
No, I lived in Erie County. Erie County is not contiguous with Orleans County.
Right.
Therein lay the problem.
Okay.
I have since established an office in Genesee County. I have since been reappointed in this and other cases to sort of cover the situation, if you will. But I submit it's a fact-specific issue. In this case, did the judge overstep his bounds? Yes. Why? It was a mistake. Is it jurisdictional? I submit that it is not.
But it was not a mistake of fact. It was a mistake of law.
Correct.
Mr. President, let me ask you this. Obviously, they appointed a special prosecutor because there was a conflict, correct?
Correct.
And then I'm assuming this county is probably relatively small, and a lot of individuals, I mean, small with attorneys. not with
44,000 people in the county, I believe, Your Honor.
Yes, and you're saying that it might have been a mistake by Judge Church, but again, I don't want to, Judge Church isn't here. I'm wondering whether there was other attorneys that they could have appointed, other than.
Well, again, I think this is a fact-bound question, and the court's bound by the facts of what happened here. I'm sure there are other attorneys in the county, but that's not a factual issue, or that isn't a set of facts that's before this court.
Right. Well, the court wasn't limited to Orleans County. It could appoint an attorney from any contiguous county, which includes Monroe County. Quite a few lawyers here. Could have appointed a lawyer from Genesee County. Could have appointed a lawyer from Niagara, if I'm not mistaken. So it wasn't just the one county. It wasn't limited.
I agree with you entirely, Judge. But if you, the problem I think I'm wrestling with, and I think this court has to wrestle with it, is all of the cases that have come out of all of the courts in New York that deal with residency issues. Again, not talking about 701, because no court's ever talked about 701.
Right.
But all of those cases that deal with residency issues say it is not a jurisdictional issue. If you look at DeFalco or Leahy, which the petitioner cites, those are cases where the prosecutor was improperly appointed or lacked subject matter jurisdiction, and the courts there said, no, that's a jurisdictional defect. In this case, my marching orders were specific to Mr. Calera. I did what I was specifically told to do, and I submit that if you...
Just a minute, that's my issue. You did what you were told to do because the special district attorney has to exercise that constitutional discretion. That's what makes this case a little different.
I'm not quite, I wasn't a special district, well, yes, I was.
You were a special district attorney
Correct.
with all the discretion inherent in serving as the constitutional officer.
In this case.
In this particular case, with all the discretion, not as an assistant who follows the orders of the district attorney. And that's what makes this case very significant in terms of the jurisdiction. Can the court go beyond the statute and give that special discretion to someone who doesn't meet the eligibility within the statute?
Viewed in hindsight, yes, Judge. At the point in time when it was made, when the appointment was made, I submit, like I said, the appointment was in error, but at the point in time when it was made, yes. We can sit here and Monday morning quarterback the district attorney and Judge Church all we want. But the residency requirement wasn't met, but I did exactly as I was commissioned to do, if that's the right word, under the appointment that made me the special prosecutor in the Calera case.
And your litany of cases say that it's non-jurisdictional.
Yes, again, 701 isn't part of those cases. The courts of New York have been silent on 701. One of the things I wanted to say to this court is, the court's going to say, well, this is a case of first impression. I submit, maybe. It's not a case of first impression because it's a residency issue that's been dealt with in other cases many times.
Under different statutes. Yes. I think we understand. Thank you.
Anything further, Judge?
Hearing none, thank you very much. The next case up for argument is case 449, People versus Goins. Mr. Schwartz, you're there. Mr. Brandt, you're there. Can both of you hear us?
I can hear you.
Brandt?
Yes.
Please proceed, counsel.
Good morning, Your Honors. May it please the court. Judge, the facts of this case are pretty simple, so I'm not going to belabor them. The people's argument seems to hinge on a finding. It would require this court to find that Mr. Goins would be allowed to waive the illegal aspect of his sentence. And to be clear, my contention is that the sentence was illegal based on the fact that he was sentenced as a second felony offender, a second non-violent felony offender, even though there was question whether he was a second violent felony offender when he was even asked to make the waiver initially at his plea. The people are arguing that he did. There's very little argument that I don't think that there's much of a colorable argument that the sentence is legal or that he is a second felony offender.
But counsel, first of all, just with respect to preservation, right? This was raised in a motion and then withdrawn, correct?
That's right, Judge. So
everybody is aware of this, but it was withdrawn, and then the plea went forward. So there's a serious preservation issue here. Is this but your point is, look, it's an illegal sentence. Is this something that's better dealt with on a 440-20 where a record could be developed?
I think
with respect to the specifics of the elements of the charges in California and how they relate to New York?
No, Judge, I don't think there are any non-record facts. It's pretty clear that this was based on that particular statute. It's not even fact-based. The people do argue a little bit that there should be a hearing with respect to the underlying facts of the California conviction, but the underlying facts under Lockwood and all of the cases are irrelevant. He was convicted of California Penal Code 664 and 459, and we know just statutorily, regardless of what the underlying facts were, that statute cannot constitute a felony in New York State because it requires an element that New York State does not. So, or I'm sorry, the other way around. New York State requires an element that the California Code does not. So it cannot constitute a felony regardless of the facts. There's no factual...
So you're saying there's no facts that can be developed below or in a 440-20 that would change the result that we can reach right now?
That's correct. The only thing...
I think we understand that argument.
Okay, thank you, Judge. And so therefore, it's an illegal sentence. It cannot be waived. Preservation is not required. It would be akin to Mr. Goins agreeing to be sentenced to 10 years, even though the statutory max is 7. It simply cannot be waived. So I think the court should send this back for resentencing.
Thank you, counsel. Mr. Brandt?
Morning, Your Honor. Please, the court. This is the second
Up, you're breaking up a little bit, Mr. Brandt. Why don't you start over? We got a little bit of a break up there.
Morning, Your Honor. May it please the court. Is that better?
Yeah, it's much better. Go ahead.
Thank you. So this is the second time we've had this argument. It was a written motion. It was brought at the time of sentencing or before sentencing. Counsel and his client, they went in, they talked with the judge, they got the sentencing agreement that they wanted to, and then they withdrew the motion and pleaded guilty. And so, I mean, this is a situation for a waiver, and that's what we'd be looking at.
So you're saying, look, it wasn't preserved, we're done. Do you disagree, though, that if it's an illegal sentence, it could be raised in a 440-20?
It absolutely could be raised in a 440-20, Your Honor.
And counsel argues, however, that there are no facts to be developed in a 440-20, and we could answer that here if we wanted to go beyond the preservation issue. Do you agree?
I don't know what facts could be developed, Your Honor, and that's the problem that we have.
You don't know what facts are developed because you haven't had an opportunity to have the facts developed. Is that what you're saying?
Yes, Your Honor.
Okay, I think I understand. Anything further?
No, Your Honor.
Thank you, counsel.
Thank you, Judge.
Case 450, People versus Shama.
Your Honors.
Good morning, counsel. You appear to be unopposed to the argument today.
That's right, Judge. I did intend to say a few words on each of the points in my brief because I consider this to be a case of grave importance for Mr. Shama. Naturally, I'll answer any questions the court likes about any or all the issues. Our first position is that 3030 time expired on the prosecution here. It looks like the central issue in debate in the lower court was whether...
Appears to be between January 20th, 2022 and May 3rd, 2022. There's about 103 days there.
Yes.
That the people do not concede, but that you claim ought to be charged.
Yes, the lower court said that this was essentially a request to hold off for plea negotiations, but...
People didn't obtain a written waiver of the...
That's right.
With respect to that, and it's got to be explicit and unambiguous waiver, correct?
This court said that in Lubner,
Yeah.
so I think that controls here.
If we rule in that way and say that the 3030 applies and your argument's correct, gets rid of everything else?
That's absolutely right, Judge.
Maybe you want to briefly address the other issues.
If the court doesn't have any questions with respect to those additional issues, I'm happy to just rest on my brief.
Any questions, counsel? No question. Or your colleagues? No question.
Thank you, Your Honor.
Thank you. Case 452, People versus Smith.
Presiding Justice Whalen, and may it please the court, I represent Mr. Smith. I'd like to address my three main points of this brief: the weight of the evidence point, the ineffective assistance of counsel claim, and the denial of the right to counsel time permitting. And starting with the weight of the evidence contention, in this single witness identification case, the people failed to prove beyond a reasonable doubt that Mr. Smith was the culprit. Presented here is not a question of credibility of the victim's identification. There's no disputing she honestly believed that she had got the right man. She had identified the right man. Instead, presented here is a question of reliability of a troubled teen's identification who made her observations from a distance and really difficult conditions, frightening circumstances, a momentary event, and gave but a vague and inconsistent description of the shooter. This court is well equipped to answer this question because it is acutely aware of the pitfalls of eyewitness identification. The salient facts which the people do not dispute cast substantial doubt on the accuracy of the victim's identification, beginning with none of the testable DNA that was found on the sweatshirt worn by the shooter belonged to Mr. Smith. Not the testable DNA found in the saliva stain, not the testable DNA found on the collar, not the testable DNA on the cuffs or the collar strings. And this fact is very difficult to explain away. In fact, the people offer no explanation for this, particularly since the shooter wore the sweatshirt in sweltering, 95-degree heat, as he pursued the victims for several blocks and then fled the scene of the shooting. And indeed, you can see the shooter wiping his brow in the surveillance video in the store. Second, none of the witnesses who saw the shooter, the suspect, after the shooting, identified Mr. Smith as the man. Not Collins, who saw the shooter flee the scene, take off his sweatshirt, not Al Materi or Mr. Lewis, who spent several minutes with the suspect in the convenience store.
Look, it seemed like the people's case was based largely on the photographs and the video taken from the convenience store and the hat that the person they claim is your client was wearing in the store. You want to address that piece of evidence?
Sure. Yes, Your Honor, of course. There's good reason why the individuals in the store could not identify my client as the individual in the store. And you can check the jury's work in this case. Mr. Smith does not resemble the man inside the store. You have the Facebook photographs. You can study them, of course. Mr. Smith has a narrow face. He has lighter skin. He has different facial features, and he is thinner.
Would you agree that the person depicted in the store with the hat was the shooter?
I think the evidence suggests that he was the shooter.
Right. So that we narrowed it down. So the shooter was the person in the store. The question is that your client? The way that people look at it is your client was sitting in court and the jury could compare, look at him, look at the photographs, which are pretty clear, and they could make that call based on their own observations.
Well, we don't know how much the jury examined my client in court. We just don't know. That's not in the record. But what we do have is the people's evidence, which they introduced into evidence, the photographs. And you have the opportunity, again, to check the jurors' work in this case. You can see from those photographs, Mr. Smith does not resemble that man. He is not that man in the photograph. And fourth, the victim initially described the shooter as somebody wearing braids, which you could see hanging from his hat. As you again can see from my client's photographs, and as Investigator Simpson conceded, there's nothing about my client's hair, his close-cropped hair, that could be mistaken for braids. And last, there's a dearth of corroborating evidence. There were no incriminating omissions. My client's not tied to the weapon in this case. He wasn't arrested near the scene of the crime, and there's no non-speculative motive. It's not enough to say the jury has spoken in this case. Jurors, as we know, sometimes get it wrong, and this legislature has empowered this court to correct it when they do.
The issue that I think is concerning is the witness, Ms. Bullock, invoking the Fifth Amendment, apparently out of fear that she was going to be committing anticipatory perjury, which you cite a lot of cases that say that's improper. You cannot invoke the Fifth Amendment if your purpose is to avoid being charged with perjury for testimony going forward. Here, the only issue, and I think everyone would agree on the law, you can't do that. That wouldn't make any sense. You can't say, yeah, I'm going to get up there and lie on the stand, so I'm going to invoke the Fifth so I don't get charged with perjury for lying. Here, really, the only factual issue is, why did she invoke? Did she invoke out of fear that she'd be charged with perjury for her testimony from the first trial, or her testimony that's anticipated that I don't remember? If it's the latter, then it's an improper invocation. Do you want to address that factual issue of how do we know why she invoked?
Yes, I would, yes. Thank you, Your Honor. And this ties to both ineffective assistance to counsel claim, because counsel did not make that winning argument, and also it's a standalone claim. And I agree, either way entitles my client to reversal. As to the factual question, the record does show that the victim was taking the Fifth out of fear that she was going to testify falsely, that she did not remember the details of this incident. We could tell first because we have the Sirah hearing testimony where, leading up to the trial, the victim began changing her story. She began telling the court, or excuse me, telling the district attorney's office that she did not resemble, did not remember who committed the crime.
Does it matter that those statements to the district attorney's office weren't sworn statements? They were In other words, it wouldn't be perjury necessarily that she's contradicting sworn statements given to the DA's office. Is that
No, but the district attorney did testify to those, and this shows what she was anticipating testifying to. This is what she was going to testify to. And then following the Sarah hearing, this is critical, the court concluded, after hearing this testimony, the court concluded, yes, indeed, if she testifies to this, I would conclude that that is false testimony and that she would be facing perjury charges. And then when the court turned to the victim's attorney and asked the victim, why is your client asserting the fifth? The attorney said, for the reasons stated by the court. And we know what the court said. And finally, after her testimony was admitted at trial, and defense counsel again objected to the admission of her prior trial testimony, the prosecution, the people argued, well, it was a proper assertion of the fifth because her anticipated testimony would be false and she would be subjecting herself to perjury charges. All right. That is not the only ineffective instance of ineffective assistance of counsel. Counsel also failed in failing to object to Investigator Simpson's many instances of improper testimony, which he gave both in direct and cross-examination. These two went to the very central question of the case, identification, whether it was his testimony opining that Mr. Smith is the individual appearing in the surveillance video after the court ruled that such testimony would be improper, his testimony bolstering the identification procedure being used in this case by saying the district attorney repeatedly signed off on this identification procedure, and speculating that the uncalled witness, Dees, could identify the shooter. He was just unwilling to testify or to share that information. It can't be said that counsel employed reasonable trial strategy in order to avoid highlighting this improper testimony. We're not talking about an isolated instance of improper testimony. Instead, we have numerous instances, and they all go to the very key issue. Ignoring improper testimony, hoping the jury would not notice, is not a recognized reasonable trial strategy, and that's recognized in this court's and the Court of Appeals' numerous decisions saying that it's counsel's obligation to ensure that a defendant's trial is fair and not infected by improper testimony. And last instance...
You raised this Fifth Amendment issue as a standalone contention.
Yes.
It's not preserved, and that's what you just argued there. A lawyer should have objected, but it seems to be a pretty high burden. He did object to the witness invoking the Fifth multiple times. He repeatedly objected to the introduction of her prior testimony. He just had, the ground he asserted wasn't quite the ground that you're arguing here.
Correct.
And given that there's no New York cases that talk about anticipatory perjury, there are a lot of federal court cases that you cited. It seems kind of a high burden to say that he's ineffective for not knowing those cases. But if we address it on the standalone, on the merits, it's unpreserved slightly. Again, he objects every which way except for this narrow way. If an objection had been lodged, what, if anything, could the people have done to counter it or the court done to correct it if he had raised the objection that you're saying?
Well, I think technically, I think it is preserved. He didn't make the winning argument. He didn't frame it this way, but the court reached the issue. The court determined that she should be permitted to assert the Fifth because she faced the potential perjury charges for the testimony that she would give, false testimony she would give. So under 470.05, it is preserved and it's reviewable as a standalone issue. But I would say that if counsel had made the argument, the court would have recognized that she couldn't take the Fifth and she would not be an unavailable witness, and therefore her prior testimony under Article 670 would not be admitted at trial.
Right. Well, what I'm saying is that usually the rule of preservation is so the court can correct an error. Here, there would have been no way to get around it.
That's right.
Your client, there was no counter steps the people could have taken or the court taken, other than not to allow her testimony to be admitted, which would augur for us reaching it in the interest of justice if we were to conclude that it's not preserved. Which you seem to suggest is not preserved because you're arguing he was ineffective for failing to preserve it.
Well, Well, I'm arguing that the winning argument wasn't made, but it is reviewable under 470.05 because the court reached the issue. We can tell it determined that she could she could assert the fifth because she feared that her testimony would be false and subject her to perjury. So, yes,
Isn't
it's
that
reviewable as a
easier?
question of law.
Well, then
But
that's
in any event, I'm sorry to interrupt, Your Honor.
But that's an easier win for you then, than going through all these errors he made and, if it's preserved because the court ruled on it, that's an easy, quick win.
That is, assuming the court agrees with me. And I've done this a couple of years and know that I can't always read the court like, so.
You should begin to wrap up.
All right. So if I could just address the last point briefly, and that is the denial of the right to counsel. Mr. Smith was denied his right to counsel during a critical plea bargaining phase of the proceedings when the court made him to decide and accept whether to decide or consider whether to accept or reject the people's most recent, most favorable plea offer of 12 years imprisonment at a point in time where there was a complete breakdown in a relationship between my client and his trial attorney. The period I'm talking about is a period between when counsel sent a letter to his client telling him that what the plea offer was, and then the court taking that offer off the table and telling him that the case was going to trial, no ifs, ands, or buts. It's undisputed that there was a complete breakdown in the attorney-client relationship at that point. Counsel said that once my client sent a letter to the Attorney Grievance Committee, he was no longer dispensing legal advice. All he did was send a letter to the client communicating the offer. He said, in his words, the attorney-client relationship was no longer there. The court, ultimately recognizing that there was a complete breakdown in the relationship, relieved counsel and assigned new counsel. The right to counsel is not satisfied by the fact that my client's attorney communicated to him the plea offer, or even that the court told him what the plea offer was. The right to counsel requires more. It requires that counsel share his professional judgment. We know this through People versus Colville. He has to dispense expert advice as to whether or not to accept or reject the plea offer, and this turns on a host of factors, of course. The likelihood of success at trial, what the ultimate sentence is likely to be. And it does not matter that Mr. Smith had counsel. There wasn't a breakdown relationship when there was a previous offer made, because at that point, the court rejected that particular offer. This offer, the one we're talking about here, is the most favorable offer, and is favorable in the sense that it's 11 years shorter than the sentence that was ultimately opposed. To just wrap up, Your Honor, to be clear, our contention here is the denial of a right to counsel, not the right to effective assistance of counsel, so thus prejudice is entirely irrelevant to the analysis, and there's no need for record development to demonstrate that had there not been a breakdown in communication, my client would have accepted the plea offer. Thank you.
Thank you, counsel.
Good morning. Marty McCarthy for the People. I'm going to start with the perjury question. I think the issue here is we're talking about perjury in the wrong way and thinking it is anticipatory perjury. It's not anticipatory perjury because perjury can be committed in more than one fashion. So in this scenario, had she testified in that fashion, she would have committed perjury not necessarily because of what she said at the second trial, but it's inconsistency to what she said at the first trial. So perjury second, and the court looks at perjury second. If you have one sworn testimony that says one thing and a second sworn testimony that says something else, that's perjury.
So you're saying that she invoked to avoid the prospect of being charged with perjury based on the fear that her testimony at the first trial might have been untruthful?
The point is, with perjury second, it doesn't matter which one's truthful. The only thing that matters from the perjury second prosecution is that they're contradictory. Okay.
Well, don't you have a problem going either way? If her testimony at the first trial was false, that's an even more significant problem. She's the only eyewitness, and his client's sitting there in prison for 12 years based on false testimony. If she's fearing that she's going to be charged with perjury for lying at the retrial, then you would agree, I think, that that's not a permissible basis to invoke the Fifth.
Correct.
So
Well, actually, no,
which one's worse? I'm not sure which one would be worse.
I disagree with, and the reason why I disagree with that is for the same reason, because if she testified, let's say her first testimony was truthful and her second testimony wasn't, can still charge her with perjury second. On those grounds, we actually don't have to prove which one was truthful or not. We only have to prove that they were consistent. Justice Del Conte, did that answer the question you had, or are you going to say something else? You raised your hand.
I'm sorry.
Okay. I wanted to make sure if you had a question, I got to it.
Shouldn't the court have done more here? I mean, as far as, you have somebody who's refusing to testify, holding that person in contempt. She came in, she was arrested, or was it a material witness warrant? What was it?
You have me at a bit of a disadvantage. This is not
Yeah,
my
you're filling
appeal.
in, we understand.
I'm
It's a
filling in,
material
so
witness.
I actually don't know, so I'm going to
Okay.
rely on you. You probably know better than I do.
It was a
in
material
that.
witness work.
That's what I would assume in that scenario. That's typically how it happens, and one of two ways happens. Either that she's actually arrested on that warrant, or an investigator from our office finds her on that warrant, and they bring her to the court.
Brings her before the court, right?
Yeah, so
And
you did
then-
have that, and then she had counsel there to advise her as to whether she should testify under those circumstances. He talked to her, and based on that conversation, what the attorney and the witness talked about, what was relayed on the record was what was going to be the subject matter of her testimony should she have testified at the second trial. Now, again, I go back to, I think, again, anticipatory perjury is the wrong way to think about it. I mean, granted, you could, there are other forms of perjury that you could charge in a scenario where you didn't have a prior testimony. You could charge perjury first or perjury third. That being said, perjury second in this scenario doesn't require truth to be established about either of the statements. They only need to be inconsistent. So an attorney who's advising her told her, if you testify in this fashion, you will be committing perjury. It doesn't matter whether it's truthful or not in that sense. That would have been his advice to her. And then based on that, and the case law is very clear, the witness is usually in the best position to judge whether they're going to commit perjury or not. Decided not to testify on the advice of counsel. And thinking about it as anticipatory is the wrong way to think about it, because it's not necessarily, it's not just the testimony at the current trial. It also involves the testimony at the prior trial. So those things combined equal perjury in this scenario. That's what the attorney was probably advising her of. And given the fact that the judge heard the substance of that testimony, what that testimony would have been, again, this is a retrial, so familiar with the prior trial, knew how she testified at the first trial, made that conclusion that that would be perjury, and it wouldn't matter which one was true or not.
So as I understand it, the only way to avoid the conclusion that it was anticipatory perjury is to conclude that she lied during the first trial.
No, I don't, again, I disagree with that because of the fact that it doesn't matter whether she lied at the first trial or
Well,
would
it
be
does
lying
matter a
at
little
this-
bit, because that's the testimony that was presented to the jury.
No, I meant it mattered, for perjury purposes, it doesn't matter whether she lied at the first trial or the second trial.
You're simply
For-
saying all you have is two contradictory sworn statements, and that's enough
That's enough.
to demonstrate perjury, and it doesn't matter which one's right and which one's wrong.
That's correct. And
Would
from
you
that
agree, though?
perspective, you have to look at the first trial testimony as part of the perjury. So
Would
that's
you,
why it's not just anticipatory perjury.
This theory that it's inconsistent, subject her to perjury second, would you agree that that theory wasn't articulated by anybody, neither Joel Crane nor Judge Renzi nor the prosecutor below?
I don't know if it was articulated or not in the sense of, it certainly wasn't explicitly articulated, but when the judge made the conclusion based on what he heard, the judge also had the benefit of what the prior testimony was. And when he made that conclusion, she'd be committing perjury, that has to be the frame of reference in which they were making that determination.
Well, the Judge Renzi, his words, he says, if she gets on the stand and says she doesn't remember, I don't think that is being truthful based on what she told Ms. Noble, who's the victim witness advocate, as recently as October. So Judge Renzi was looking at it like her testimony wasn't going to be inconsistent. He was saying, that's untruthful, and that'll subject her to potential perjury. Those are his words. Then we go to Mr. Crane. Mr. Crane had just walked in the courtroom at that point. Mr. Crane says, based on what the court is telling me, that this testimony, I don't remember, is untruthful, I would advise her to take the 5th. Then they take a break. Crane meets with Ms. Bullock and back, and then he comes out, and then we got some further clarification. Crane says, for the reasons she's taking the 5th are as stated by the court on the record earlier this afternoon. So they were, Judge Rensley thought the perjury was going to be based on the anticipated testimony. The prosecutor then later says, yeah, that's what it was. Now, that doesn't mean that's Ms. Bullock's mindset, but.
No. And again, when you look at perjury, you have to look at it from the perspective of the witness, not what other people may think about it. Now, in terms of what she told the victim witness advocate, I think Justice Whalen, you pointed out, things that were told to the DA's office, those aren't sworn. So in essence, I don't know how, if we were to proceed on that theory, I don't know how it would have been perjury. But when you have two inconsistent testimonies, clearly that is perjury in that scenario. In terms of, did we cover, do you think I covered enough?
Up to you, counsel. You
Okay.
can make your argument. You should begin to wrap up.
Yeah, I'll wrap up. In terms of, I'm just going to touch on the right to counsel issue very briefly. When you say that this was a critical stage, the critical stage was a plea that didn't happen. And in this scenario, this wasn't a trial in which a defense attorney wasn't present. This was a plea that didn't happen, and there's nothing in the record that indicates that, one, the defendant ever would have pled guilty, or two, that just because the judge said, no pleas, that's it, you're going to trial no matter what, that he would have not reconsidered that position had the defendant sought to pursue a plea offer after the appointment of new counsel. That needs to be developed in the 440. If there are no other questions?
Thank you, counsel.
Thank you.
Case 455, Gaskill versus Sharp.
Good morning, Your Honors. James Strauss. on behalf-
One second, counsel,
sorry,
if you wouldn't mind. I think
I
we
was
have,
looking around. I know Peter's supposed to come on.
right, we have Counsel Hall.
Your Honor, Mr. Hall is not checked in, or he has not come in either, so.
Very good. We'll proceed then. Proceed,
over.
counsel. Pardon me?
Case over. May it please the Court, James Strauss on behalf of the appellants in this case, Causley Trucking and Jeffrey Keith Madden. Simple story, Your Honors. Causley Trucking has a facility in Lockport, New York. They house their trucks there. They have a big parking lot where the trucks sometimes park. Directly across the street from that was a house where Mr. Sharp was in. Mr. Sharp came out of the house with Mr. Gaskill as a passenger in his car.
We understand the facts of the case. Counsel, here's what I'd like you to address, if you could.
Sure.
What the court below, as I understand it, and please correct me if I'm wrong, you know the record much better than I do. The court below had a motion for summary judgment before it, and usually the argument is you get one bite of the apple on a motion for summary judgment. But in this particular case, the court ruled below that it was denied without prejudice. And the court's view was, I believe there needs to be a development of more facts here. All right? We've got a situation where this motion is brought to the court before depositions are done. I have that correct, right?
Correct.
Yeah. And so it's being done on affidavit, right? And part of the argument is that we need to be able to challenge those affidavits at a deposition. We need to develop the facts surrounding the allegations in the affidavit more fully. And the court below agreed with that argument and would allow you to go forward at the conclusion of the depositions with a further motion. Do I have that correct?
That's correct.
Okay. And your argument, I think, as I understand it, is there's nothing to be developed. The affidavit set forth all of the important facts. They're not challenged. It doesn't matter whether the truck was partially in the road or not partially in the road. That doesn't change the facts of the happening of the case, that the car backed into the truck that was not moving. And it's as simple as that, and there's nothing further to be developed.
Well, indeed, Your Honor, I would say that not only did we move by affidavit, but Mr. Gaskell's affidavit is completely consistent with Mr. Madden's affidavit. Mr. Gaskell testified, Mr. Sharp, in his affidavit, he said Mr. Sharp backed out of his driveway at a high rate of speed into the roadway where he collided with a truck.
And
That's Mr. Gaskell's testimony.
That's Mr. Gaskell's, that's the plaintiff's testimony.
Correct.
Mr. Sharp, however, takes the position that, well, there is some inconsistency, right?
No.
Well, let me ask you this. Doesn't Mr. Sharp take the position that the vehicle, the truck, was partially in the road where the affidavits of your clients are? No, it wasn't. It was in a parking area and not at all in the roadway. That's a distinction, right? You would argue that it doesn't make a difference, but that there's a distinction there, right?
No, it's not Mr. Sharp, it's Mr. Gaskell. Mr. Sharp did not put in any opposition to our papers.
Mr. Gaskell, that's where there's the distinction, though.
Mr. Gaskell says we were in the culvert of the street.
Right.
But the Mendrakowski case, which this court issued, and I could read the language to you, it's really directly on point. The court said, even assuming arguendo that the truck was improperly parked, let's assume that it was, we conclude as a matter of law that the location of the truck merely furnished the condition or occasion for the occurrence of the event and was not one of its causes. So here, the issue is the cause of the accident. And here, it's VTL 1211A, it's Mr. Sharp not looking behind him, it's your own decisions, both Judge Lindley and Whalen, you were both on the sorry, I have my notes here. Pardon me. You're both on the Gill versus Brash case. Mm-hmm. And Judge Whalen, Judge Lindley, you were on the Prees versus Jones case.
Remind me about that case. Was that case a case brought after full discovery and depositions were complete, or was that done solely on affidavit?
I don't know the answer. I mean, I have the case, I could let you know. But what you said is the sole proximate cause of the accident was defendant's negligence. Mm-hmm. And the whole issue was defendant didn't look behind him. They drove in reverse. It's a 1211A case. Plaintiff doesn't cite a single case to hold us into this case.
Part of the argument here, as I understand it, and again, is the flashers. They say that the emergency flashers were, your side says they were on and activated.
Again, not a material issue.
Let me finish the question, please, counsel. And the other side says they weren't on, right? Now, I don't know that there's a dispute that the car that backed up into your truck was at fault for the accident. I don't know that the other side will even dispute that. The question is, was there fault by your client? And what they're asking for is an ability to develop the record and not have this done based upon just the affidavits. You're saying, as a matter of law, based upon these affidavits, there's nothing to be decided?
100%.
Okay.
Similar to a rear-end collision case where somebody says, hey, you were not you're not riding at a perfect distance away from us, you ran into my car. It's a VTL case.
So we have to closely, I think the way I'm looking at this is we have to closely read those affidavits that were submitted on your motion to determine whether or not there is any question relative to possible finding of negligence relative to the truck and the driver of the truck.
Correct.
Okay.
Both parties say the same thing, which is the truck was
We'll take a look
parked
at that.
and
Is there anything
sat.
further, Counsel?
Yes, I will say,
Counsel,
with
before you
respect
get
to
to your
the...
next point, could I just ask you clarification? The case that you're saying you're relying on that I was on, is that Gill versus Brash? Is that the case?
Yes, Gill versus Brash.
183D 1415. Could you remind me of the facts of that? Was the parked car that was struck, was that parked in a legal spot? I forget now.
It just says that the defendant's negligence was as a matter of law because the car backed into a pickup truck into plaintiff.
Right, well, see, again, I
So
remember
he hit
reading that
plaintiff.
case last week. Nobody here is going to dispute that Mr. Sharp was negligent for backing in. That's not the issue, and that, as I recall, that was the issue in Gill versus Brash. We're talking about, was there some other fault? We can have more than one proximate cause here of an accident. You would agree here, would you not, that there's issues of fact as to the placement of the truck when it was parked, whether it was straddling the road or whether it was in a parking lot? You would agree there's a factual issue on these affidavits?
I would agree that Mr. Gaskill says that, but
Yes,
I
so
also
that's-
say that
that's-
it's not a material issue.
Right.
It's not a cause of the accident.
I understand.
As
but
you say in
You
Mandrowski.
agree there's an issue of fact on that?
No,
You say not a material,
right, non-material issue.
so there's an issue of fact on where the truck was parked, right?
Yes.
Yes.
Let's say that.
Right, I don't know why it's so hard for you to say that.
No, it's not. I agree.
There's a material issue, there's an issue of fact, maybe not a material one, but an issue of fact of whether the flashers were on.
Yes, again, not a material issue.
Correct.
Not even close to a material issue.
Yeah. So the question is, do those facts matter? You're relying on Gill, and we can...
And Priest Jones.
Yeah, so that's really the question is, what would you say if the car was parked right in the middle of the road?
I'd say-
And Mr. Sharp backs into it, still the same result?
Absolutely. Because
If the-
Mr. Sharp
if the
had an
truck
obligation
was-
to look behind him and avoid the accident.
What if the
That's-
truck was parked illegally on the wrong side of the road, Sharp doesn't see it and backs in? No liability, no contributory fault or
That's
causation
correct.
by the truck? So you can park wherever you want, however illegally, if someone backs into you, you are totally free of any liability.
Well, what you're asking, if you think about the practical fact is, if I see a car that's parked illegally, why don't I just intentionally back into it and get myself injured and say, well, they were parked illegally, so too bad for them. The point is that he has an obligation to look behind him. If we parked behind his driveway
Sharp,
so that he
obviously,
couldn't get
again,
out, he still
Sharp's
doesn't have the right to
negligence-
drive.
Sharp's negligence is not at issue. Nobody's going to dispute that.
Right.
So, but I will we will all read the cases that you cite and see if they are on all fours. There was some other issue I think you were going to before I rudely interrupted you.
No. I mean, I think the flashers is really a non-issue. Whether they were on or not doesn't make a difference. Again, I point to the Mandrowski case where you say that the issue is, was this the cause of the accident? Was our location the cause of the accident? Even if we were on the culvert of the street, that's not the cause of the accident.
Not the cause.
Correct.
Not the a cause. That's what our standard is. Was it a cause of the accident? And that's a critical distinction, is it not, Counsel? There can be more than one cause of an accident. We can all agree on that, right?
Well, the language of Mandrowski is it's not one of its causes. That's what it says. Right. But here, it wasn't one of its causes, nor could it be.
That's
Nor
your
could it
argument,
be.
we understand that.
You know, I mean, it's not like Mr. Gaskill ever said, hey, the flashers were on and Mr. Sharp didn't see it. And Mr. Sharp chose not to oppose our motion. Mr. Sharp never said, hey, I didn't see the flashers, or I did see the flashers, or I should have seen the flashers. He didn't participate in this at all. So it's really just plaintiff's testimony saying, I ran into a parked car. And all our parked car cases are cited. So with that said, if you don't want to move, I mean, I could talk about the sanctions issue, but if your position is that we can't get summary judgment, then the issue of sanctions
We're
is a different
not
issue.
taking, our position will come out in a decision.
Okay, so then let me talk about the sanctions issue
Go ahead.
just for a moment. And I hate to personalize this, but imagine if you live in a home with a driveway on a street, and your across the street neighbor gets into a car with a passenger, drives backwards across the street that you live on, drives into your driveway and hits your car sitting in your driveway. And then the passenger gets injured, sues your across the street neighbor, and sues each one of you for liability. That's what this case really is. It's egregious that we were sued because we were hit while standing, whether in the culvert of the street or in our parking lot. We shouldn't have been sued. It's not a case that should have been brought against us. I think we know the reason why we were sued. Doesn't have to be said, but it's egregious. Just like the situation I just gave you. You would find that situation egregious.
I would say the facts are a little different. One vehicle's parked unlawfully, another one is lawfully parked. May not mean any difference in the result, but your example of me just parking in my driveway, that's a little different than here, assuming the facts as alleged by the plaintiff.
Right.
The truck was parked straddling the road, which I don't believe would be a lawful place to park.
Well, there's no ticket given to us for being parked illegally, and indeed, the police report has us on our parking lot. Okay, Mr. Gaskill can say what he wants to say.
Again, the allegations are that it was moved afterwards. Now, I have no idea what happened, nor do we.
Yeah.
And that's just the point, is that the court says, well, let's have a little discovery. Let's put some people under oath here. and find out. But you may well be right, that the law is what the law is, so we'll have to take a look.
So in that sense, we ask for sanctions. The last thing I want to say is that while Mr. Sharp's counsel is here today, he didn't oppose our motion below. So I don't think that he preserved his right to oppose our motion or our appeal here.
Thank you, Counsel.
Thank you. And I do raise that in my briefs.
Very good.
Good morning, Your Honors. May it please the Court. My name is Rob Caggiano, appearing on behalf of Respondent Christopher Sharp. Just briefly, Your Honors, and I believe you all touched on it, really the sole issue that we, in response, are asserting is that the motion practice, and although it's not up on appeal, there was a cross motion which was all heard together for summary judgment by the other respondent plaintiff. The argument we presented was that it was just too soon. We had not, at the time of the motion practice, done really any sort of discovery, let alone party depositions. I would note to date, we still have not done any party depositions, so therefore the only underlying facts that, at least for my client, and I don't speak for the plaintiff respondent who was not present today, but they also made similar arguments, is 2 affidavits that are merely pages long that we have not had any ability to cross-examine or impeach in terms of their credibility, that Your Honors have already noted there are some sort of discrepancies with regard to the position of the appellant's truck.
Great. Well, what do you say to the cases that he cites? There's a number of them on page 24 of his brief. The Gill case is one of them, the Jones versus Time Warner, that it doesn't matter, these factual issues are not material. It doesn't matter if he's on the side of the road or safely ensconced in a parking lot. He wins either way.
Yep.
How do you address those cases?
Your Honor, I would address those cases. It's my understanding, and I apologize if I'm incorrect, but those decisions were all made and those motion practice were all heard after depositions and discovery had been completed and the facts had been at least developed.
Right, but why develop facts if the facts are not material?
I would argue, as I believe Justice Whalen had asserted, that his opinion that it's not material is incorrect, as there is not only one cause of an accident. The position of the truck, I would argue, is material to the extent that it could have been a contributing factor to the accident, and given the position in the roadway, given that the underlying case and the accident here does involve a very narrow street.
Right, so you disagree with him on the law, that if the car was parked straddling the road, obviously Sharp's going to be negligent, but there could be some fault as well by the truck driver.
I would agree, Your Honor, with regard to that argument. That is something that the plaintiff responded to argue in terms of proximate cause of the accident and contributing factor. Again, I would just note that our argument being presented is solely on the fact that discovery has not been done. We made that argument in oral argument.
Is part of your argument that, just by way of example, and I know that you make reference to the flashing lights not being on, there's a discrepancy there, whether the truck had flashing emergency lights on or not. At a deposition, might some of the questions go to the driver as to what was the purpose for putting the flashing lights on? Was it to notify other vehicles on the road, going by the car, going near the car, operating near the car, that that vehicle was there so that they could see it? Might those be questions that might be explored on examination at a deposition?
All of the above, Your Honor. And again, that's our position. We'd like to do discovery, and the underlying court has already allowed for the appellant, if necessary, to reintroduce this motion, if necessary, after discovery is done, by making the ruling without prejudice.
Very good. Anything further, counsel?
Unless there's no other questions.
Thank you.
Thank you very much.
Case 457, Merchants Preferred Insurance Company versus Campbell.
Proceed, counsel.
Good morning, Your Honors. Brian Barnes for the appellant in this case, Merchants. The trial court made multiple errors in this case that are going to be the focus of my arguments, that had those issues been decided correctly, Merchants' motion for summary judgment and default judgment should have been granted in this case. The first is the trial court didn't take a position on what law applies in this case, but the only conclusion that's supported by the record is that New York law applies. And the reason for that is the mode of analysis used in a contract case, which is the grouping of contacts analysis.
In this particular case, we had the policy issued in New York. Am I right about that?
Policy was issued in New York.
The insurance company was based in New York?
It was, Your Honor.
The insurance agent was based in New York?
It was, Your Honor.
The policy was issued with New York specific forms?
It was, Your Honor.
And the insurance car principally garaged in New York? Do I have all that correct?
That is all correct.
Okay.
And that is all the foundation of the reason why New York law applies to this case. And the second point, it seems contradictory, but it's not, is that when you're applying New York law, New York insurance law 3420 has a timely disclaimer requirement. That was the only basis for Charlace's argument in the trial court that the disclaimer was improper. And that statute doesn't apply in this case. And the reason for that is very simple. It's because the statute, by its plain language, only applies to accidents that occur within the state. Nobody here is disputing that this accident took place in Florida. There's binding case law from this department on this issue. There's also a case of Brennan in the second department, which was a 204-AD 2D 675, which, much like this case, involved an accident that took place in Florida. Court there said the timely disclaimer requirement doesn't apply. So our position is Charlace's only argument below was that the disclaimer was invalid based on 3420 D2. Since that statute doesn't apply, that argument has to be rejected.
We have common law, the common law disclaimer, aside from the insurance law. That might lead to a different analysis. Your point on that is what?
Yeah, Justice Lindley, we addressed each of those in our reply brief. Our first position on that is those arguments were waived by Charlace when they weren't asserted below. If you look at the arguments made below, there was no mention of the common law defenses. They were clearly aware of those defenses based on the fact that they had raised them in their answer. Had they wanted to argue them and brief them, they certainly knew they existed and had every opportunity to do so. Similarly, if you look at their brief on appeal, there's no reference to estoppel, there's no reference to waiver, there's no reference to latches. So to the extent those were ever preserved below, we would argue they've been abandoned for purposes of the appeal. If the court wants to look at the merits of those, we addressed in our reply brief why each of those would not apply here. The main reason that kind of runs through all three of those is Merchants here made it aware of what was going on in this case. It sent cooperation letters to its insureds. It tried to get their cooperation. And the point I want to make on that is I think the fundamental mistake with Charlace's position in this case is that it should have been clear right away somehow that it would have been futile to obtain the cooperation of the insureds. Right? The case law on this in New York is pretty well established that just the mere inaction or lack of response by the insured to attempts of the insurer to obtain the cooperation, that's not enough to disclaim coverage for lack of cooperation, which is why Merchants didn't do that here, right? They tried, they sent out multiple investigators, they sent multiple letters, they visited the insureds in person to try to get them to cooperate. It was only after it was made clear, in no uncertain terms, by the insureds that they wouldn't cooperate that the disclaimers were ultimately issued. And finally, unless the court has questions, I'll direct the court to, there's a case that we cited in our brief. It's called the New York State Insurance Fund versus Merchants. It's a second department case, 583D 449. And the reason I bring that up is it's one of these mere inaction cases. And there, the court found that where the insurance company couldn't get in contact with the principal of the insured entity for 18 months, and that was their position. We disclaimed we couldn't get in contact with them for 18 months. The court said that's not enough. You have to show that they willful and avowedly obstructed your efforts. That's about the same time period we're dealing with here. This lawsuit's filed in February of 2019. Merchants attempts to obtain cooperation from ultimately those efforts fail based on the willful and avowed obstruction, and it's in May of 2020 and July of 2020 the disclaimers come out. So our position is merchants did what it could to try to get the cooperation needed in this case. It only disclaimed after it became clear that those efforts were not going to be able to succeed and that New York law applies and the timely disclaimer requirement doesn't. But even if it did, I would submit to this court that we comply with it.
Thank you, Counsel.
Thank you.
Good morning, Your Honor. I'm James Myers. I represent Rose Charles. We disagree completely. First of all, in terms of the choice of law, the policy itself is very clear. The New York State Insurance Department mandated this out of coverage. In the language that we cited and that we argued is that based upon that language that is contained in the policy, that you have to apply Florida law. Now, they cite in their reply brief a case, which is matter of American Insurance Company versus ABDLGHANAY 80 NY 2D 162 1992. That's a Court of Appeals case, and that case will control in terms of how the law is applied. They are relying, the policy uses the language that they have to that they must provide not only the minimum type of coverage, but the kind of coverage. The court in that case made absolutely clear that, and I'm going to read what it says. Although the legislative history of Section 5103 is not extensive, it demonstrates the purpose was to ensure that the carriers provide not only the amount of coverage, which is what they cited it for, but that type of coverage minimally required by the state in which the insured is visiting. The regulation implementing the statute specifies the policy must provide at least a minimum amount and kind of coverage which is required in such cases under the laws of such jurisdiction.
Yeah, we have that provision in front of us. The way the other side reads that provision in the policy is that if I'm driving in another state with insurance I got from New York, the minimum here is whatever it is, 15, 25, whatever. If I go to another state and the minimum liability limits are higher,
Yes,
the carrier has to honor those higher limits, right?
that's correct.
Correct. Now, you talk about the word kind.
Kind of policy.
Kind of policy. You say then, your whole argument is kind of policy talks about choice of law.
Yes, that's what
I read kind of policy as different types of coverage that are available. If another state requires coverage for different things and New York doesn't, and I drive to New York, well, then my policy has to provide those kinds of coverage. The issue is choice of law here. Is there any case that you've seen with this provision, which is very common, where somebody drives out of state and they say choice of law? This means wherever you drive, the driver's subject to choice of law in that new jurisdiction based on this provision?
First of all, in the case I just cited, the issue there is whether or not New Jersey law applied or New York law applied, because in New Jersey law, you do not need any physical contact in order to recover under the uninsured provisions. In New York, you required physical contact. What the Court of Appeals said in that case is that New Jersey law, that New Jersey law applies because it's the kind of policy. That's exactly the type of issue that we have here.
What's the site on that case you're talking about?
Well, I'm going to give you two sites, Your Honor. The first one is 80 NY 2D 162, but I'm also going to give you the case in which the Court of Appeals also cited in that case, which is All City Insurance Company versus Williams, which is 120 AD 2D1, Second Department 1986. Now, At that time, and there was a division among the appellate division as to what the choice of law should be applied. The first department took his position. The second department, which was ultimately the position the Court of Appeals took the other one, and let me read you what it says. The court did not perceive the issue to pose a choice of law problem as the colleagues in the first department. Where the choice of law issue, if they were going to apply it, then they would do it the analysis that my opposing counsel said. But as we view the matter, however, the issue is the meaning of the New York insurance policy, the requirements of the New York insurance law and the regulations promulgated under it. Since the insurance law and the regulations mandate that under the circumstances, like the instant ones, the requirements of New Jersey law be incorporated into the New York contract. There can be no question of choosing between the laws of the two states. The law of one is incorporated into the law of the other. That is the decision in the Court of Appeals in 1992 said, yes, that's how you have to analyze the coverage that is provided, because the insurance department mandates that coverage.
All right, we'll take a look, but the implication of your argument is that anyone who drives in New York and leaves another state, they're subject to the laws of the other. There's no choice of law. It's always the other state.
It's incorporated by the terms of the policy.
All right, do you want to address, if we move on, I think that the case really kind of turns on the Thrasher factors. If we're applying New York law, we have the factors of whether a carrier can disclaim for non-cooperation. There's a number of different factors.
Again, I want to go to the Court of Appeals in terms of the Continental Casualty versus Stratford case, that's 11 NY 3D 443, in which before they start to discuss the section 3420, they state, even if insured possess a valid basis to disclaim for non-cooperation, it still must issue its disclaimer within a reasonable time.
That's common law, right?
That is common law.
Which is unpreserved.
What?
Is your common law claim preserved?
Well, sure, absolutely.
Where in the record did you argue it below?
We argued it, in fact, well, first of all, let me backtrack just a little bit, because in the beginning of this case, they in their replies, and this is in the record, they argued, that they not argued, but their affirmative defenses stated, merchant disclaimer coverage based upon lack of cooperation of its insured was timely and complied with insurance law section 3420.
That's statutory?
Yeah.
Not common law, yeah.
No, that's statutory. That's the one that requires that they provide the notice as reasonable as possible.
And then there's common law issues.
Right. But then they switch their position on this motion in which they says, well, 3420 doesn't apply, but that you do have to apply, for example, the question of, you say Thrasher. I say under the facts and circumstances of this case in which they received the notice within 9 days, they hired their investigator immediately. Within 60 days, the investigator says there's no question of liability. You paid the property damage claim. They then proceed through the years, barely, they don't really contact the guy, but they know that there's no cooperation. In November, they say their insureds aren't going to cooperate. That's 2017. We then provide them all the medical, everything, you name it. It then gets sued in 2019. What do? They then hire a lawyer, and that case gets actively litigated in the state of Florida. They do the depositions of a client. They engage in whatever discovery they engaged in.
Right, we understand. Then they disclaim right at the end there. But can I just ask you this, because you're running short on time? there's no dispute that the insured failed to cooperate here. I think you would agree with that. They didn't give notice of the accident, they didn't give notice of the lawsuit, they wouldn't respond. There's no dispute that they failed to cooperate. It doesn't
From day one.
No dispute. It doesn't mean that they can disclaim coverage under Thrasher, because what they have to show, the carrier has to show, lack of cooperation is a given. They have to show that the carrier acted diligently in seeking to bring about the insured cooperation. And they have to show that their efforts were reasonably calculated to obtain the insured's cooperation. And they have to show that the attitude of the insured was one of willful obstruction. Your argument is they didn't establish, the carrier didn't meet its burden of establishing that the efforts they took, whatever they told them over the phone, was reasonably calculated to get their cooperation. One way to get it is, hey, look, you can ignore us all you want, but if you don't cooperate and there's a judgment, it's coming out of your pocket. And if we have to pay, we're coming after you. Those would be reasonably calculated to get cooperation. They didn't make any showing of what efforts they made to get the cooperation. That's your argument.
That's part of the argument, but again, a case that this court decided, which is argued in the briefs in the United States Fidelity and Guarantee 275 AD 2D 977 4th Department, in which this court found facts less strong as ours, that there was equitable estoppel. Now, we pled equitable estoppel at the trial, at the oral argument. If you read the oral argument, we argued this case in terms of equitable estoppel, that there's no question, that issue was in front of the trial court. But here what you have is you have this person in Florida, seriously injured. She did everything she had to do. And now they wait well over 3 years to disclaim, under New York law. And again, I believe you have to incorporate the prejudice requirement under the cases that I just cited to you, that is part of New York law now as a result of the Court of Appeals decision.
We'll take a look at that, Mr. Myers. You should wrap up, sir. Your time is up.
If my time is up, I think the conduct of merchants in this case, I think this whole quote, to document the non-cooperation was a complete sham. They had no reason to question the liability of this case. There was nothing that they were going to get from their insured. They knew it. They set it up so that they could try to walk away from it. It's against the broad public policy of the state of New York. We want to protect, we want to provide for innocent both victims. That's why we were named in the case.
Thank you, counsel.
Thank you.
Case 458, Kirschler versus Village of North Collins.
Your Honor, I'm marked as submitted.
Counsel, you have asked to argue today. My understanding, and Mr. Ryan, you can confirm this, that you have no objection to counsel arguing?
No objection, Your Honor.
Very good. Counsel,
Thank you.
your opponent's very kind to not object. You can proceed.
Good morning, may it please the court. Todd Bushway on behalf of the defendant Village in this case. I think that the first question is, what is the duty, or how do you judge the duty of the Village in this case? And I think there are two theories put forth. One is a general negligence standard of a premise liability that a property owner would be subject to, and the other is the duty of a party acting pursuant to a contract, the case law that follows from Espinal, the Espinal Court of Appeals decision.
Let's talk about the Espinal, factors here, right?
Okay.
And what I'd like you to address, if you could, for the benefit of the court, is the argument about launching a harm. Right?
Understood. I think the other two are clearly not an issue in this case.
So let's focus on that one just for our purposes, and this is my question.
Sure.
the village had certain limited obligations under the contract, and that was to drop salt, essentially.
Correct.
Right? And nothing else. No maintenance of the parking lot, no repair of the parking lot, no design of the parking lot, nothing like that.
We're not even plowing it.
Right, not even removing the snow, just dropping the salt. And I think, if I'm reading the record correctly, the village would sometime on its own determine when to drop the salt. And sometimes we're called and said, hey, we need some salt dropped.
I think the record reflects that it would occur in both circumstances.
Right.
One is if they knew that it had been plowed, they'd go over, or perhaps they'd be called and then they would go.
We have cases in this court that address, for example, plows moving snow around and pushing the snow around. And this is, not your obligation, I understand it, but follow my question. Moving snow around and changing the condition of the weather on the parking lot in such a way that it resulted in ice forming.
So just putting it up on the uphill side and it runs down and freezes and.
And it freezes, and we've got those cases that said that could be determined as launching a.
I would agree with that.
Right. My question to you is this: how are those cases different than dropping salt if an expert says, by virtue of dropping the salt, that action changed how the ice turned to water, how the water moved, and how that then froze and caused a dangerous condition? How is that action not also launching a source of harm?
Well, and I think the distinguishing factor is, in one, you have an affirmative conduct, putting the snow where you shouldn't have put it, uphill, whatever it might be. That's clearly creating.
But how is dropping salt not changing the condition of the parking lot, thereby creating whatever condition flows from the dropping of the salt?
Well, if that is deemed to be creating, my client doing, the contractor salting, and I'm assuming in your example that the salting is being done where it's supposed to be done. It's not somewhere other than whatever the agreement called for. In that case, I don't think performing as intended and doing nothing else can be creating a hazard. If you're doing what you're obligated to do, and you don't do something beyond what you're obligated to do.
How is the snowplow operator, in pushing the snow out of the way, not doing what they were obligated to do? It's just that by doing that, they then created a condition.
I think the assumption in those cases is that they had another option. In other words, that where they chose to pile the snow is the problem. I actually tried one of those cases, and none of the cases seem to talk about that factor, but the assumption has to be that there would have somewhere else they could have put it, other than the place that's causing the problem.
All right, now let me ask you another question. Thank you for that answer. And then I'll let other judges who may have questions jump in. But would you argue that whoever designed the parking lot, whoever caused the parking lot to flow in anticipation of water hitting a parking lot,
right.
There's flow sometimes put in design, and this is how we get rid of water on parking lots, right?
Drains put in places.
If the parking lot is designed in such a way that if snow hits or ice forms and salt is put down, that the water then flows in a particular way that is dangerous, was the condition launched at the time the parking lot was designed, and therefore not necessarily subsequently by the salt hitting the parking lot? Do you follow my question?
I think I do, and I think the issue that I have with that analysis is that would put anybody who's applying salt, which by design is intended to take whatever's there and convert it to water, would be, unless that evaporated, or if it refreezes before it evaporates or runs off, then merely by putting salt down, you're going to be deemed to have created a condition. And I think that's I don't think that's what Espinal stands for. You're doing what you're contractually obligated to do, and you didn't, by doing that, cause a problem. I would also point the court to...
Counselor, let me interrupt
Sure.
you for just a minute. As I read the plaintiff's expert affidavit, he indicates that putting the salt down made it worse. This was not an ultra-hazardous parking lot until you put the salt down. And when you put the salt down, the water ran right to where the teachers were walking into the school. And in addition to that, it was the wrong product. You were using sodium chloride, and he suggests there's some other salting techniques that could have been used here that would have avoided this dangerous condition.
Well,
Isn't that what the expert says?
I believe so, but I think that again, you're pointing to my client's hired to put down salt, and you're saying if I do what I'm contractually hired to do by the district, who owns the property, I'm creating a hazard. So if I don't salt, does that put my client in a position where the school's now going to say, hey, we have an agreement, you're supposed to be salting?
You're not taking the position by having a contract, we don't have any responsibility.
No, I understand, but I'm just saying that I don't believe that just by merely doing what we were contractually obligated to do, which was apply salt to the parking lot, that we can be held liable for creating a condition. I think there has to be something more.
But that's not necessarily the issue here. The issue here is there a question of fact on that?
But in that scenario, the alternative is my client does not do what we're contractually obligated to do.
Were they contractually obligated to put that particular kind of salt down?
It just says salt, it doesn't specify.
Because the argument, I think Justice Alconte's question is premised on the fact that the expert was saying wrong salt, made it worse off, made it more dangerous.
Well, and the other part I would add to this is I'm not sure that the record supports the contention that whatever was there, and the plaintiff testified she wasn't sure what she fell on, was created by something that my client had done days prior. If the question is you didn't salt...
Is it better left for a battle of the experts and the factual determination at the time of trial?
Well, I think that the burden of proving the exceptions in this case, I think, falls on the plaintiff. The other point I would point out is the court has held numerous times that if the allegation is you should have put salt down that morning to deal with the conditions that formed overnight, merely not, this court has held numerous times, Messler, Lingenfelter, that not doing something is not, does not create a condition. One of those cases has to do with salt, and one has to do with plowing in a certain location, where the allegation is, hey, you didn't do that.
Right, if you do nothing under the launching theory, you're good. If you do something that makes it worse, you're bad.
Well, I think
that's
in a real general sense, yes, you have to do something.
Can I shift gears a little bit? It seems like Mr. Ryan's primary argument is he relies on the argument of the Hall versus the city fence case. Justice Niemoyer, as a trial judge, issued decision there when you have one governmental entity providing services for another that changes the analysis. So he's going outside of Espinal on this other ground. That's his point one. What do you make of the Hall case?
Well, I think there's 2 points to that. One, the section of the statute that's mentioned in Hall, General Obligations Law 119-0, which allows for intermunicipal agreements, doesn't contain any language to suggest you should interpret those contracts any differently than you would any other contract, number one. Number two, Hall does not stand for the premise that Espinal doesn't apply to municipal contracts. First of all, the party that was seeking summary judgment on Hall is the city of Buffalo, which was the property owner, so not the party that's acting pursuant to the agreement. It's the property owner, and what the court decides is, under the terms of that agreement, the city had retained certain obligations for maintaining the park. And the court said, there's a question of fact, because the city has retained certain obligations. This isn't a complete, hey, county, you're now 100% responsible for this area. And because there was retention of obligations under that agreement, there was a question of fact as to whether the city was responsible for the conditions that led to the accident, or could be held liable for the accident.
Counsel, you said in your agreement that it stated that nothing in this agreement will relieve the property owner from the responsibility and the ultimate care and liability of the person.
Right. I'm just saying that what I'm saying is Hall is, first of all, it's not the contracting party that's moving, and second, the court looked to the actual terms of that agreement and said, hey, city, you kept some of this. And if you kept some of this and you're being alleged that you didn't maintain the property, that's a question of fact. So that would be my...
Thank you, counsel.
I appreciate your questions, Your Honor. Thank you very much.
Good morning, Your Honors. I'd like to jump right into the General Municipal Law 119-0 argument. The question of whether or not Espinal applies to this, and it seems like opposing counsel is saying there's nothing in 119-0 that says Espinal does not apply. That's not the right way to look at this. Espinal solely applies to common law contracts. It's a common law issue. I think we can all agree on that. This contract, if you want to call it a contract, it's actually expressly labeled an intermunicipal agreement. The parties intend on it being an intermunicipal agreement. Is statutorily created. That is different from Espinal. That's different than every Espinal case. I shepherdized it this morning. There still isn't a 119-0 case with Espinal that I can see. All right? And because of that, you have to look at what the statute actually says that authorizes these municipalities to work together in a joint service agreement. It says that you are sharing the responsibility. You are actually accepting the duty of another municipality that in this case might have a non-delegable duty. The other cases that I cite with 119-0, we've got some that are police departments that decide to work together to accept the duty that's non-delegable to the municipality. We've got some town and highway departments that decide to do it. Either way, they are coming together to decide on their own, we are sharing this responsibility. And it's expressly stated in this agreement that that was what the intent was, for them to take over the salting responsibilities for this parking lot. And that's what happened here. The problem is they never did it the right way. Right?
Doesn't it says in paragraph 6 of that agreement that nothing herein shall intend nor shall relieve the school as a property owner the responsibility and ultimate liability for the condition of said property?
It absolutely does say that, Your Honor. The problem is there's nothing in the law that allows you to completely immunize yourself from responsibility here. That provision is subject to 119-021, which is cited in my brief, which actually says that the risk allocation can be brought or can be agreed upon between the parties to the agreement, right? And so that's like, Your Honor, like, I admire you so much, Your Honor, for everything that you've accomplished. I'm going to say I'm going to indemnify you for anything you do the rest of your life. All right? I'm on the hook. You rear-end someone, they still got to sue you first. They got to bring the case against you. There's nothing that I can do or anyone else can do that can immunize you against law. That's all there is to it. And here, the village is the proper party to sue because they're the one with the duty to salt. I'm also going to put in, like, from a practical perspective, outside of just the legal argument that general municipal law accounts for, there is no third-party claim against the school here. All right? In the record is the insurance contract that's actually the school's insurance contract making the village an additional party to it, which is what that provision requires. So everything that's being done is not based off of what the duty is, what your respective party's suing. It's just the risk allocation provision, Your Honor. And going back to, again, like, with the overarching facts here, you know, Judge Whalen, just going to the creation, launching force of harm, I just want to point out this court's decision that came out 2 sessions ago, Garcia v. Black Sea Properties, LLC, specifically with launching the force of harm argument. And in there, it says expressly, if you can't say what you did, you can't get summary judgment based on launch of forcing harm. And that's what happened here. Like, I'm sure Your Honor's noticed the delicate dance that's going on here with, did we salt? Did we not salt? If we didn't salt, you can't launch the force of harm. But if we didn't salt, then we had notice, and then that would be liability if 119-0 applies. You can't get summary judgment with that, Your Honor. And that's what we have here. And like I said, expressly on point is the Garcia case. It's also the Begenfeld case. And those expressly address those issues. You know, going to Hall, it's always hard when you only have trial court decisions, right? And there are 2 orders mentioned in this specific order that's cited that's available, at least to me, on Westlaw. And so it's true, in that order, it is the city that moves. But if you look in the order, it expressly states that there was a prior motion by the county, right, who was in the joint services agreement under 119-0, who also moved to say, we did not completely displace the city's responsibility, therefore, we should be out on summary judgment, the same argument that they're making. And Judge Moyer denied it because the shared services agreement expressly states what your duty is. You agreed to it. Not only did you agree to it, right, the only way these agreements under 119-0 are allowed is if your board votes on it. It's legislation. It's essentially creating an ordinance. This is what you're responsible for. And I think the most, in my view at least, the most applicable aspect of Hall for what we're dealing with is the footnote 4, where Judge Nemour basically explains his logic for that rationale.
We'll take a look at that, counsel. Anything further?
The only other thing that I just want to mention, Your Honor, is with regards to the what's put forward by our expert. There is no contradiction by the defendant. Like, we push that forward. There is nothing in opposition to that. If we're just going by the mechanics of the law, 99 times out of 100, that's summary judgment for the party pushing that forward. We didn't see that at the lower court, and I would just emphasize again the lack of opposition to oppose what our expert said. And then the final thing, Your Honor, is just with regards to causation of the injury. Regardless of what we're arguing here, there's no doubt that she suffered an injury from this fall. Thank you, Your Honors.
Thank you, counsel. Case 459, Williams versus City of Buffalo. Counsel, proceed.
Good morning, Your Honor. May it please the court. Andrew Kovalevsky on behalf of Appellant City of Buffalo. Your Honor, this appeal stems from a denial of summary judgment that the City of Buffalo's police officer, 1, is entitled to the reckless disregard standard of care, and 2, was not reckless as a matter of law. Here, it's clear that the standards for reckless disregard were met in the summary judgment motion. Officer Norwood, who is the City of Buffalo police officer, was driving an emergency vehicle. That point has not been disputed by the plaintiff. He was engaged in an emergency operation of the vehicle. That's in dispute. And that's in dispute, and I'll get into that in a moment. And the other was whether he was performing a privileged driving activity, and that issue is in dispute as well. In regards to the emergency operation issue, Officer Norwood testified that he was responding to an alarm call on Nash Street in the City of Buffalo.
Let's help me here with the call timing, okay? And I want to use military time here. And I want to go right to the physician call, which there's no dispute about that. That was at 16:31, correct? Officer Norwood takes a call from his physician at 16:31:59.
That is the call that is contained, the timing in his cell phone records.
Right.
Yes.
And then Officer Norwood says the accident happened after I spoke with my physician, after I completed that call.
Correct.
Right. But the issue here is we have the food market video that says that the accident happened based on the video, that what it was captured in that video, somewhere between 16:32 and 16:32:11 and 12, which would have been at the same time the officer was on the phone with his physician. Two different timestamps, two different times.
Correct.
So you agree that if we, just looking at the timestamps, we've got some inconsistency as to when this accident took place?
No, I would disagree. I guess there's three different timestamps in general here we're talking about. There's the City of Buffalo records, which you have the call summary logs, and the City of Buffalo surveillance camera. That's one set. You have the Willard Park food video timestamp, which is a minute to a minute and a half ahead of the City of Buffalo times.
Right, that's your position, but there's nothing in the record that tries to put these timestamps together in some kind of a jigsaw puzzle. We're left with separate, of the same event happening at different times according to the timestamps.
I respectfully disagree with that assertion because there's only one accident, right? So we know that is a definitive thing that happens. We know, based on what plaintiff is arguing, that this accident happens at a certain time in the Willard Park food video. We know from the City of Buffalo surveillance cameras that rotate that it happens within a certain period of time. There's only one accident. So just by comparing that time frame between the Willard Park food video and that time period that's in the Buffalo surveillance video, we know that the Willard Park food video is ahead of the City of Buffalo times in their timestamps. That is in the record, and it's, I think it's been explained.
There's one other piece, though, that the plaintiffs have, and that's that witness who says that the officer had the phone to his ear at the time that he made the left-hand turn.
Correct. And that issue speaks to I think whether his conduct was reckless, not as to
Well,
whether...
in terms of the timing and understanding, because I think what the plaintiff is saying is the officer's testimony is not necessarily consistent with the timestamps and not consistent with the witness who says he was actually on the phone. His position is, I completed my call, and the accident happened seconds later. I was off the phone.
Correct. So let's assume, for the purposes of summary judgment, which we must do, that the facts alleged by the non-moving party, we assume those, that's the case, right? So let's assume that because of the witness statement, which is not sworn, but let's assume because of that statement that Officer Norwood is holding a phone up to his ear and the cell phone records that he's using a cell phone while making the turn. That does not remove him to whether he's engaged in an emergency operation of the vehicle under a law. That question goes to whether he's reckless, whether his conduct is reckless, not whether the recklessness standard applies.
I mean, I'm sorry to interrupt you on this, but where I'm struggling is his testimony is, I returned to the call, the alarm call, after I finished my cell phone call. If he's still on the phone at the time of the impact, by his own testimony, he has not returned to the level 3 or level 4 alarm call.
I have to take a look at the transcript for a definitive answer on that question, but I think his testimony is that I'm not sure if that's accurate. I know here's what the time frame is. He initially has the Nash Street call. A higher priority call comes in. He switched to that call is on One Birdway. It goes to the One Birdway call. This is all documented in the Buffalo complaint call log. He investigates that. There's nothing there. I believe at that point he says, sign me back up for the Nash Street call. If he takes a phone call from his physician after he gets signed up from the call, assuming that is correct, assuming that it's properly before this court, that still does not remove him from the emergency operation of his vehicle. This court has made it very clear that when an officer is engaged in responding to an alarm call, no matter the priority of the call, whether it's lights or sirens or not, whether it's a priority 1 or priority 5 or anywhere in between, you're engaged in an emergency operation. There is nothing from the appellate division level or anywhere in this state that says that being on a cell phone, if that's true, removes you from the emergency operation of a vehicle.
But if it were to be decided that he did not re-engage and wasn't on a call until after he got off the phone, then he's not in a 1 through 5. Would you agree with that? He hadn't re-engaged yet because he was still on the phone with the doctor. Isn't that what we're looking at here?
I think his testimony, I wish I knew your question ahead of time. I'm sure everyone has said that here, or has thought that.
Or thought it.
Yeah. No, I think his testimony is that the testimony is that he goes to the Birdway. He then says, I think the testimony is, then he goes, says he puts back on the call. He gets put on the original Nash Street call, and then maybe the phone call happens, and whether he's engaged in the phone call or not. I think the City of Buffalo complaint summary shows that he's engaged in the
And that's really,
operation.
I mean, in fairness to you, I mean, you didn't anticipate the call. We need to look at the record, is what you're saying. And if, in fact, he's engaged in your point is, if he's back engaged immediately prior to the happening of this accident, then it doesn't matter whether it's a 1 through 5.
That's absolutely correct.
Yeah. If he wasn't back engaged, or there's a question of fact about that, then that's something that ultimately should be decided by a jury.
Yeah, and I think in this case, now that I'm thinking about your question more, here we have a situation, not only do we have the records themselves, but where is he going, right? He is making a left turn to go to the Nash Street address, which is 2 blocks away at the time of the accident. Now, that is undisputed.
Right, that's
So
certainly
that's
evidence, yeah, that's certainly evidence, might be evidence for trial, but to be, does he need to re-engage into the first call? He gets diverted to the fight, he goes there, the people are dispersed. To get re-engaged in that initial call, does he need to call that in or be directed? Or can he just, in his mind, say, there's nobody here, I'm going to start driving back to the original spot, and then later say, by the way, I'm still responding? Or what if he never calls at all? He's still, in your mind, engaged in that first call.
That's absolutely correct. And in many cases in the appellate division, don't have call logs where you officially assign a call. When a police officer sees a crime or does whatever and starts to respond to it, he's engaged in emergency operation. So even whether or not the call, there's a question about whether he's on the phone or not, he's making a left-hand turn to go to the alarm. That's his testimony, and it's undisputed that he's going there. There's no evidence in this record that he's doing something else other than responding to that call by making a left-hand turn at that intersection to go to Nash Street.
What comes of the fact that he is calling in to let dispatch know that he's re-engaging in that call? Does that not tell us that he's not engaged in the call until he gets re-engaged in the call?
I think that is evidence that he is engaged in the call for Nash Street, but it's not definitive. That would be my position on
We'll
that.
take a look at that. Anything further, Counsel?
One further thing, and I think this is important as to the argument that plaintiff's counsel is making here, and that is about the disregarding regulations governing turning. And plaintiff's counsel has made the argument that Officer Norwood must intentionally disregard those regulations, meaning in his mind, I am going to make a left-hand turn by failing to yield the right of way to respond to this call. That is an argument that has never been made before any court of New York that I can tell. I have not seen that argument at all. And it runs counter to what this court did in Williams v. Fassinger, which is a Fourth Department case from, I believe, 2014. In that case, it's factually the same as this one. We have an officer making a left-hand turn under a green light. He looks for oncoming traffic, thinks it's clear, makes the left-hand turn and is hit. So if Officer Norwood is engaged in the emergency operation of his vehicle, he's also engaged in a privileged driving activity by making that left-hand turn under a green light when he's struck. And as a result, the reckless disregard standard applies. And I'll touch briefly on the issue of recklessness. Even if you were to assume, based on this witness statement, which is unsigned, and I think there's evidentiary issues which are well briefed in the brief, that Officer Norwood, and this is what she said, has the phone up to his ear, waits for oncoming traffic, and then makes a left. That's not recklessness as a matter of law. Recklessness as a matter of law, or raising a question of fact as to recklessness, those cases require an officer to take his eyes from the road, looking down at something, not looking in a certain direction before making a turn. Here he does look for oncoming vehicles. The cell phone use is really a red herring. He's not looking at the phone. It's not distracting his vision in any way.
Right, he was doing about 10 miles an hour. If a citizen was involved in an accident of this nature on a cell phone, fail to yield the right of way, there would be a stretch in your view to charge that person with reckless driving.
Correct. That would be certainly evidence of negligence,
Yes.
which is a momentary lapse in judgment. It is not evidence of recklessness, which is a far different standard as a matter of law.
But he's taking a call from a doctor's office. I mean, you don't know what the subject matter of that call was either.
That is not in the record. All we know is that it was a
True.
call from his personal doctor, but regardless, that still would not affect whether it's reckless how he was driving the vehicle or whether the reckless disregard standard would apply. And secondly,
You should begin to wrap up, Counsel.
Yeah. The appellate division in Johnson, which is a snowplow case, has held that using a cell phone is in fact not reckless as a matter of law because it doesn't show a conscious indifference to your actions. So I'll rest on my papers, Your Honor, unless there's any further questions.
Thank you, Counsel.
Thank you.
May it please the court, Lawler Quinlan on behalf of Melvin and Evelyn Williams. There are two reasons why the statute doesn't apply here. And let me start with the central issue that we raised in our brief, and that is the fact that he did not disregard the regulations applying here. Ever since this court and then the Court of Appeals decided the Caber versus County of Monroe case, it's been the law in this state that the standard, that unless a police officer, if it's a police crash, unless the police officer is actually exercising one of four delineated, limited privileges in the statute, then the standard to be applied to his or her conduct is ordinary negligence, just like any other driver. No matter how bad the emergency, by the way, how pressing the emergency, the standard is ordinary negligence unless the officer is actually exercising one of those four things. And the one at issue here is, of course, disregarding regulations governing directions of movement or turning in specified directions. My learned friend reads that statute as if it were to say, number 4, instead of disregard regulations, it said turn or travel in any direction, notwithstanding V&T otherwise. It doesn't say that. And in the case of Crisione, the court always looks at the terms of the statute, but in the case of Crisione, the Court of Appeals on this statute made it very clear that any analysis must begin with the plain meaning of the relevant statutory provisions. And the provision here is, did the officer disregard regulations? Disregard is a transitive verb, and so it means, according to Webster, to pay no attention to or to treat as unworthy of regard or notice. And treat what? Other traffic? No, treat regulations as unworthy of regard or notice. I laid out, and I can give you a little blurbs of it here, but the officer Norwood in this case, I asked him at one point, because I wanted to know if we were going to be here, he was going to be invoking this statute. And it was very clear he was not exercising one of those privileges. He said, I asked him, I understand that sometimes an officer will not yield the right of way because he's responding to an emergency. But it sounds like you're saying that you were just trying to follow the normal rules of the road in making a normal left-hand turn. Answer, that's correct. I can go on and on with a number of examples, but they're all in my brief. Later on, he says, hey, I would have yielded to him if I saw him. I would have yielded. I was trying to follow the normal rules of the road.
Well, counsel, let me just, I'm sorry, but your position, though, is he had the phone to his ear when he made the turn.
And I'm going to get to that, too.
Okay, but that would have been a violation.
Absolutely. A violation of vehicle traffic law, which is not, the regulation 1222 or whatever it is on cell phone use, is not one of the four privileges. You can't ignore that as a police officer. So I will, and I'm going to come back to that promise, Justice Elkadji. But here these, I said to him, I get what you're saying. Your claim is that you are trying to comply with the rules of the road at the time. That's the opposite of disregarding regulations. He's trying to comply with them, right. And you believe that you actually did comply with the rules of the road at the time you're turning. Absolutely. So it's our position that he definitely, in any fact finder, and really for this court to say that he was disregarding regulations when he says, I'm trying to follow the regulations, is really turning it on its head. It's not, it's totally inconsistent. He was absolutely clear, unequivocal, unambiguous. He was trying to follow the rules of the road. And now, not Officer Norwood, but his attorney is claiming, oh, he was disregarding those regulations. And again, it's disregarding regulations, not disregarding traffic or risk. It's regulations. He was trying to follow the regulations, no doubt about it, and that's why the statute doesn't apply.
The statute talks about 1104B, the things you can do, the privileged conduct, driver of emergency vehicle. One is to proceed past a steady red light or a flashing red light or a stop sign, comma, but only after slowing down as being necessary for safe operation. That type of language isn't included in the paragraph that you're talking about. Disregard governing regulations on movement and turning and so forth. Does that distinction mean anything?
Yeah, I think it's actually significant, Your Honor, that it's there, because it's in all three, not just one. So you mentioned the standing parking. The proceeding through a red light is you have to slow down. If you exceed the maximum speed limit, so long as he does not endanger life or property. And yet, in the fourth one, they didn't do that because they have this disregard. It involves the consciousness is in the word disregard. It's a decision whether to follow or not.
It's implied there, is it not, that you aren't just going to blindly pull in go into somebody's lane of traffic, right? That's kind of implied with the whole statute here, is that, yeah, you can do that. You can go in the opposite directions, drive down a one-way street, or go make turns you're not supposed to turn, but you can't do it without regard to oncoming traffic.
100%, Your Honor. It's implied. And for example, let's switch the hypothetical. A guy accidentally goes down the wrong way on a one-way street. And he's not doing it because it's an emergency. He's got to catch someone or pursuing someone. But he's trying to do ordinary driving as if you're going to Tim Hortons, you know, and there, even though I understand the priority calls, we can get to that. But let's assume he says, I'm just trying to follow the rules of the road, and he accidentally goes the wrong way, and someone comes back another driveway thinking all traffic's coming from this way, and boom, they get hit from the other side because they got a police officer unknowingly going the wrong way. That's a hazard. That's not what this statute was meant to protect. The legislative purpose of the statute, that according to the Court of Appeals in Saarinen, is the evident legislative purpose is to avoid the second guessing of split-second decisions that are made in the field under highly pressured conditions, and not to deter emergency personnel from acting decisively and taking calculated risks in order to save life or property. Your Honor is exactly right. He was not making a calculated decision. He wasn't weighing the risks and like, hey, I think I can beat this guy, but I got an emergency I got to respond to, and so I'm going to come. He was normal driving.
Just made a mistake. Now, counsel will say that you're asking us to look at a state of mind of the officer here. And he goes to great lengths saying there's no state of mind cases ever. This would be a case of first impression. Do you agree with that, and how would you respond?
I disagree with him, and especially in this respect. I didn't choose the word disregard. The legislature chose that word. They could have done active verbs as they did in the other three. They could have said in number 4, instead of disregard regulations, they could have said an officer may turn or travel in any direction notwithstanding a provision of the VNT to the contrary. They could have done that. They did not. And Christian says, use the word disregard. Disregard means you're regarding things and making a decision. Exactly as Your Honor
It's
pointed out.
inherently state of mind if the word disregard means you're thinking.
It does. That's the literal term in the statute, and it has to be given meaning by this court. And they say that, you know, one of the comments was this is going to encourage dangerous behavior. And this court has 3 decisions, all on this point, and I think it's important. I put one in my brief. Well, they're all 3 in my brief, but I emphasized one, Lagrasso. So Lagrasso, the officer comes up to the stop sign, and he stops, looks both ways, proceeds, doesn't see somebody, gets in an accident. And if my friend were defending, he would have said, well, he went through, doesn't matter, he went through a stop sign. And the court says, no, the statute says you're allowed to proceed through a stop sign. He didn't do that. And even though, which is safer, stopping and looking both ways or running the stop sign? Stopping and looking both ways is safer, of course, and that's what we want drivers to do normally. But this court said, if you did the safer thing, because you did the safer thing, you don't get the protection of the statute. It only applies if you're doing the more dangerous thing. Okay? Then again, in auto, red light. The officer says, I went through, I had a green light. The other person says, no, you didn't, you have a red light. And the court said, well, if the jury believes the officer that he had a green light, then he was doing the safer thing. And he's not entitled to this special protection of the statute because he wasn't exercising one of those 4 things. He could have, if he wanted to, slow down, look both ways, and go through a red light, but he says he didn't. And therefore, because he chose a safer course, we're not going to, they didn't say it as a matter of law, they said, let a jury decide whether he was disregarding the light or proceeding through a red light or not.
If counsel's right here, that responding to a call is emergency operation, you can do whatever you want, then you have a situation where we know there's high priority calls 1 through 5. Let's say there's a lowest level priority call, said, could you go check on this witness? You can do it today, tomorrow, whenever, just get to it at some point. If an officer responds to that type of call, not emergency, and is following all the rules of the road rationally, saying there's no need for me to speed, there's no need for me to go through any red lights here, but then inadvertently speeds or does something that's contrary to the law, in his analysis, that conduct is privileged. in your view, it would not be privileged.
In my view, if you're going to assert one of those privileges, you have to actually exercise the privilege. This man, Officer Norwood, did not decide to disregard the rules of the road. He was trying to follow them. And because he didn't disregard them, he doesn't get that special protection. The third case I was going to mention is McLaughlin. And that was a speeding case, Your Honor. And it came up, and this court said, well, geez, we can't tell on this record whether he was speeding or wasn't speeding. If he was speeding, we'll give him the protection because he's exercising one of the privileges. If he wasn't speeding, if he was doing the safer thing and abiding by the rules of the road, he gets no protection. And so you send it back to the jury to say, you know, was this guy trying to, or not trying, was this guy exercising one of these privileges? And he wasn't. Now, Justice O'Connor, I promise you I'd come back to your issue, and my learned friend said that there are 3 clocks. There's actually 4. You have the 2 videos, and you have the Buffalo Police complaint report, and you have the cell phone records. So there are 4 different clocks here, okay? The one thing we know about whether they're synced is that the 2 videos are not synced, okay? We know that much. So they happen at different times. Other than that, we don't know. How it could have been easy for the city of Buffalo to put an affidavit from one of its officers saying, hey, our complaint summary timeline matches our cameras. I don't know if that's true. I can't imagine, I'm the only one who's a little suspicious. Why didn't they do it if it's true? If they're lined up. Are they off by 10 seconds, 20 seconds, 2 minutes? We don't know. We don't know on this record. We don't know if the cell phone company, and as Your Honor pointed out, if the cell phone lines up with the Willett Park, he's on the phone for sure. Now, it's not my obligation. I'm not moving for summary judgment. They're moving for summary judgment. If they wanted to show that, oh, it doesn't match, then do so. We don't know, Justice O'Connor. You're 100% right. We got 4 clocks. We know the 2 don't line up. We don't know if any of them, the other 3 match in any respects at all. And so that gets into the issue of whether he's on the phone. And then that goes to emergency operation. I know there's a bunch of cases that say that even if you're on a low priority call, if it's a call, it's a call, you're responding because Vehicle and Traffic Law 114B, Court of Appeals and Christione says, if you're responding to a call, you're involved in emergency response, and you can do one of those 4 things. Only those 4 things, though. You can do one of those, and you get the protection. And the focus has been on the call. Is he responding to a call, okay, a radio call? There are also cases on the respond part of that. Are you, not whether the call was a legitimate emergency or not, but whether you were responding. And I said in 3 cases, they didn't have any response to one of the cases, Rodriguez, where the court says, even though you're responding to a radio call, the question of fact is whether you, as you backed up into a parking spot, to park your car, that was part of your emergency response. Were you actually responding as you did that? Similarly, I had the Torres and Jordan cases, both Second Department cases, where one's an ambulance, one's an officer, and the issue is, was he responding? They focus on the responding, not the radio call. I get it. Burglary call is going to qualify as a call. I get it. But is he responding to it? And suppose you say, just as a hypothetical, I'm going to put me down, and that's the phrase used, put me down as responding to this call. Okay? Put me down as responding to this call, but I'm going to lunch. I'm going to go to the bank, and I'm going to do 6 other errands before I get to it. Do you get close? Is that considered responding to an emergency call? Now, this is not as egregious as that, but if you're on a personal cell phone with your doctor, are you actually responding to the emergency call? You may, even if you're driving, even if the direction your head is toward it, are you actually responding? That's a factual question to be decided.
So you should begin to wrap up.
Okay. So one thing I did want to address, and that is this issue of the dangerous response. I've pointed out that this court has decided that in 3 cases, the more dangerous conduct gets rewarded or gets protected, and the less dangerous does not. And the point of that is because that's what the statute says. The statute allows you to do 4 things that we generally don't want people doing. Stopping in the middle of the highway, going through stop signs, speeding, disregarding regulations regarding turning. These are all dangerous. You only get the protection if you're doing one of those, if you're actually exercising a privilege to do that. And I can't sit down without addressing the Williams case. This is different factually. This testimony in this case that was not present in the last Williams case was we have unequivocal, unambiguous testimony that he's trying his damnedest to follow the rules of the road. There's no question of fact that he is not responding or disregarding the regulations. That's the factual distinction. It's also legally distinguishable. My friend points out that this is a novel argument. It is. And it's novel in the sense that it has never been decided either way by this court. It's never been adopted, and it's never been rejected because no one has given this court the opportunity to consider the issue of what does disregard regulations mean? Is there a mental component? Obviously there is. And I hope that this court would treat this opportunity to rule on that with the same spirit of equanimity that the Court of Appeals did in the Kabir case. In Kabir, as you'll recall, the officer is responding, he loses where he's going, looks down at his computer to see where he's going, and ends up looking up and he has too little time to rear-ends the person. When the attorney for the County of Monroe, I am sure, said, when the Court of Appeals was leaning towards, well, maybe we can say he wasn't exercising one of these four things, the attorney for the county probably said, as my friend says, wait a second, you can't do this. You already decided in the Zerbiak case 14 years ago, almost identical facts. In Zerbiak, the officer's driving down the road and he looks down not to check his directions, but to actually turn on his emergency lights because it's a real emergency. He looks down, turns it on, and he looks back up, he hits a kid on a bike. Very, almost identical, inadvertent, looking down, not paying attention. And if you, Court of Appeals, are going to decide it differently in Kabir, why you should have done that back in Zerbiak. Are you saying that was wrongly decided? And the Court of Appeals, and I put in my footnote on the brief, looked at it and said, yeah, you may have a point there, but they, the plaintiffs in Zerbiak, didn't raise this issue. They didn't make this argument. We didn't have a chance to address it. And maybe we would have decided differently under the rule we're asserting today, but no one gave us a chance. I'm giving you a chance to address this disregard regulations. I would hope that this court would send it back with an instruction that the standard is ordinary negligence. At the very least, I would hope that the court would affirm that the jury ought to decide, was this an emergency response and was he disregarding regulations?
Thank you, counsel.
Thank you.
Case 460 AB 511 Doe versus Lindenville Central School District. Proceed, counsel.
Good afternoon, may it please the court, Ryan Smith on behalf of the Lindenville Central School District. As the court's aware, this is an appeal of a summary judgment decision. It's a CVA case dating back to 1986 to 87 involving allegations of abuse by a teacher against a 5th grade student. There's no dispute in this case that there was never a complaint or report made about this teacher before the incident in question. There is no dispute in this case that the plaintiff himself or any family member or friend ever made any such report or complaint against this teacher. And uniquely, I think, in this case, despite the fact that it's 40 years old, we had 6 former employees come in and testify who happen to still be around, all of whom said they had absolutely no knowledge that this teacher was up to any sort of wrongdoing. And several of them included teachers who worked not only in the same building, but in classrooms adjacent or 2 doors down to where Mr. Hausman taught. In our motion for summary judgment that the trial court denied, the court found 3 issues that they determined created a question of fact. One of them concerned the plaintiff being allowed into the building early by a janitor. One of them concerned an allegation.
At the direction of the teacher?
I believe that was the allegation,
right?
Yes, Your Honor.
Okay.
And that no other students were given that early entry. Like there are kids waiting outside and, okay, you come on in.
That's what the plaintiff testified to.
And one of the other students that was there and witnessed this also, I think, testified that when he got in, finally was allowed in, that the student was actually in the teacher's classroom.
That's correct, Your Honor.
Okay.
And I will address that.
All right, so that's the first thing that the court relied upon below. And I interrupted you, there's a couple more.
That's all right, Your Honor. So it was being allowed into the building early. It was allegations that he was removed from classes or activities during the school day.
and it was an alleged incident where a teacher supposedly walked in when the abuse was happening. The issue with the janitor, for one, the plaintiff never
Let's
testified.
get to the third part first, right?
Yes.
The teacher, what was the name of the teacher? Was it Byrne?
Ruth Bain.
Bain, thank you. We actually have that teacher's testimony,
We do.
and that testimony is that that teacher didn't see anything.
That teacher has absolutely no recollection of ever this incident happening, denies that she ever saw anything to indicate that Mr. Hausman was abusing any student.
So the
including
only
plaintiff.
testimony that would go to, that she knew something there, would have been the student himself, who talked about what position he was in vis-a-vis the teacher when she came into the classroom, and what her reaction was to it, which I think, according to the plaintiff in this case, was unmistakable in terms of her reaction was she saw what was going on there. That's contrary to her not remembering anything that took place. But that's a factual dispute, isn't it?
Respectfully, Your Honor, I disagree, because the plaintiff's testimony about this, and it goes into the way the classroom was set up, and if you look at the courtroom, if you were to imagine the entrance of the door being in the lower right corner, Mr. Hausman's desk was situated kitty corner in the far left corner. There was a bookcase near his desk, a 4-foot tall bookcase. There were papers all over his desk, and even in plaintiff's brief, they acknowledged that someone would have to actually walk into the classroom to even see if the teacher was at his desk.
I think your argument is that Bain couldn't have seen anything based on the setup of the room, so therefore we'll believe Bain. But for the placement of the papers and the books, him saying she walked in and saw us, and her saying, I didn't see anything, that goes to trial for the jury, right?
Respectfully, Your Honor, that's where we disagree, because the plaintiff cannot speculate to what someone else saw. The plaintiff testified at his deposition that she was startled.
And she walked in and looked at them.
According to the plaintiff, she I don't even know if he said that she looked at them,
All right, well,
but
it's a fair
that's the
assumption.
implication.
If you walk in a room, you're not going to ignore the people you came to see, but you're saying, even without the obstructions of the books, him saying she walked in and appeared startled, that doesn't create an issue of fact because she just simply denies it, even though she might have some motivation to deny it, that she was responsible for ignoring sexual abuse going on in the school. But that we're just going to believe her as a matter of law and disbelieve him.
That's not exactly our position, Your Honor. Our position is look at the totality of the circumstances at issue here. They're alleging that this teacher walked in when the abuse was happening. The plaintiff testified that I was standing between the teacher and Ms. Bain when she came in. This is a 5th grade student. The teacher was sitting down and he was blocking her view. And I know counsel has tried to decipher, what was in response to was he blocking the view. There was no objection to that question. There were objections throughout this deposition. And that question was asked clearly in line with other questions about where the plaintiff, Mr. Hausman, and Ms. Bain were situated when she walked in the room. And the plaintiff testified that when she walked in, he was blocking the view of the genital region, turned around, his hand came off the pants, and that Ms. Bain was startled. And then it goes on, well, why do you think she was startled? What did she say anything to indicate she was startled? The plaintiff said no. Then we get an affidavit in response to a summary judgment motion saying, oh, wait, she let out a loud gasp, she stumbled over her words, she was clearly distraught, yada, 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 in this affidavit that we submit was clearly submitted to create a question of fact.
It was tailored.
Of course it was.
Okay.
This deposition went on for hours, and there were a number of questions asked about what happened with that incident, because clearly that's an incident that is material to the case. But when you look at the totality of the circumstances here, even if you assume that plaintiff's version that she walked in when this occurred, which she obviously disputes, and she's around, and she testified, she'll testify if there's a trial, but she carried on a conversation with the teacher after she saw this kid's hands in his pants? I mean, what sense does that make? And, Your Honors, I realize this is the Appellate Division, it's the 4th Department. You typically don't get involved in credibility determinations, but you've also had holdings where you've said it is appropriate to make a credibility determination. And that's a Finley case that's cited in our brief. And respectfully, that affidavit should not have been considered by the trial court and shouldn't be considered here. And looking at that deposition transcript, there is nothing other than plaintiff's speculation that this teacher
We'll take a look at that issue. I
supposedly saw
think
something.
you made that argument. Why don't you move on?
Thank you, Your Honor. With regard to the janitor, Mr. Whipple, plaintiff's longtime friend, was questioned about this janitor, which, by the way, the plaintiff himself never, ever testified to, was never mentioned in discovery, it never mentioned in his deposition. It came up a year after the plaintiff's deposition that he was let into this building early. Mr. Whipple, who was a classmate of his, said, well, I didn't think twice about it. He was held back a year. Everyone knew he had trouble with school. And there's a number of cases that are cited in our brief to the point that a student getting one-on-one help with a teacher is not notice that the teacher has a propensity to sexually abuse a student. There is nothing unusual about a student working with a teacher one-on-one. And that is clear from the case law.
Would you agree that the knowledge of the janitor and Ms. Bain would be imputed to the school district, assuming that those facts happened, as far as these causes of action?
Your Honor, that concept I would not agree with. It's not subject to this, it wasn't specifically argued in this appeal, whether that would be the case or not.
I thought their argument was that Bain's knowledge means that the school had knowledge, and that's the whole basis of liability, but maybe I misread it.
Well, I would agree that the case law is definitely on that side, Your Honor. I can't really sit here and dispute that it wouldn't be imputed. Obviously, our position is that she had no knowledge to impute.
Right, no, I understand that, yeah, okay.
Regarding the removal from classes, supposedly, or activities, the plaintiff, when asked about this, had no idea when it happened, how often it happened, or even what specific classes or activities he was removed from. And even if you were to credit that testimony and say, well, there's still a question of fact, our argument, which we believe to be a strong one, is that this was his regular classroom teacher. This was his 5th grade teacher. And even if Mr. Hausman said, hey, stay back from lunch, I want to work with you on something, that is not evidence of a propensity to abuse a student. It wouldn't be evidence to anyone, to a principal, to a superintendent, to anyone that knew about such a thing. This was his regular classroom teacher. And that is the distinction in a lot of the case law that we're going back and forth with between the sides. This is his regular teacher. It's someone that it's not unusual for a student to be spending time with, especially one who struggles academically. Unless there are any questions, Your Honor.
No further questions,
Rest on
Counsel.
our papers. Thank you.
Thank you.
May it please the court, I just wanted to address a few of the issues I had relative to Ruth Bain. The fact that Ruth Bain was in the room while my client was being abused goes to constructive notice. It goes to what she should have asked, what she should have done, whether an investigation should have proceeded following that interaction between Ruth Bain, my client, and the perpetrator, who were in the same room at the same time. No other students were in there.
Counsel says that Bain denies any knowledge of this occurring, and on top of that, that the student's testimony by itself isn't enough to demonstrate that Bain, even if you believe the student, would have seen anything. How do you respond to that?
I disagree with the characterization of Ms. Bain's testimony. Initially, Ms. Bain testified in response to a question that I believe to be leading, that no, I would have never done that in my career, I would have never done that. But then when she was cross-examined at her deposition, she testified that although she worked with this man for 2 decades, she had no knowledge of any interaction with him at all during the entire 2 decades, or of him with a student. When she was then pressed further, she started recalling other details about how they would have movies in his room and other interactions, but she testified she had no knowledge of any interactions. Her testimony is entirely inconsistent throughout. There's severe credibility issues as it relates to this witness. Initially, she said there were never instances of sexual abuse at the school, and only when we prompted her with specific names, she was like, oh yeah, that situation. So I think there's a credibility issue relative to her testimony on this particular incident in general, just based on what she said. But as far as my client's testimony of her reaction, that's circumstantial evidence, what she saw or what he believed that she saw based on her response. And his testimony was what the court relied on. The court relied on his deposition testimony. That's what was cited in the order. Although he did submit an affidavit, and for various reasons I indicate in my papers that they're not inconsistent. It's just an expansion of questions that were not asked relative to the circumstances of the room. I only wanted to raise as well, no witness comes in and testifies that Ms. Bain could not see what was going on or the interaction. The fact that even they were in close proximity to each other behind his desk raises a question as to why she wouldn't have said anything, regardless of whether she saw the abuse. But there's no indication in the record that the bookcase was 4 feet high. They said it was 4 feet long and that it was about waist height. And so there's no, and the papers were on the front of the desk. There's no indication that when she walked in, she couldn't see them. She engaged in a conversation with them. So according to my client's testimony, at a bare minimum, it should be a question of fact for a jury on that particular issue. I only wanted to also note the second department recently found in the MCV AWCD Doe case in March of 2024 that multiple instances of abuse on school property go to constructive notice. My client was abused almost 100 times, all on school property. So to say that you just didn't know, or to have teachers come in and give self-serving statements that, no, we were so shocked we didn't know, especially with the credibility issues, I think is a question of fact.
Wasn't there testimony also about conduct that was taking place in the hallways between this teacher and other students? Inappropriate hand contact in the hallways that was open and obvious to anybody that could see it?
Yes, Your Honor. In addition to the janitor letting specifically this client in, my client in, to school with no indication as to what the reason was. There's no indication in the record that the reason was that he was having trouble with school. And then he would proceed, my client's testimony was that he would proceed to the classroom to be abused at that time on numerous occasions. But also the inappropriate touching of male students in the hallway, grabbing at their genitals, giving crude comments like, you know, you like it when teachers were around. That goes to a question of fact on the issues of negligent supervision and retention. The fact that he was consistently alone in the classroom, called out of other classrooms, and the fact that Patrick Whipple, and I just wanted to make a comment that you can't hold teachers to a fifth grader's standard. Patrick Whipple was a fifth grader in the classroom at the time, so his testimony is relative to what he saw as a fifth grader, and he saw that it wasn't right, to the point that they were making fun of our client, saying, this guy loves you. So I think his testimony in the fact that they have an in-local parentis duty should be a question of fact for the jury on these facts.
Did the, last question for me at least, the Mr. Hausman, the teacher, he was convicted of sexually abusing another student.
Yes.
Did that abuse take place before the alleged abuse here, or did it take place and was discovered after? I'm sure it was discovered after, but what's the timing of all that?
The criminal action occurred after. There's 2 pending civil actions, but they were not. One was there was a statement in the criminal file that was included as part of the record from another client who has an action other than this that preceded 5/11, 5/24. But no, the 1990 criminal investigation only occurred in 1990, which was after the abuse in this case, when that student went specifically to a parent and the parent insisted that they do something about it.
But that conduct took place after the conduct here?
Yes.
Okay. Thank you.
Thank you, Your Honor.
This court will stand in recess.
Thank you, Your Honor.